All right. I think I'm live. Let me refresh over on the YouTubes so I can see how all of you wonderful people are doing today. Are you ready for this? I'm excited. I'm excited for this. I anticipate today to be kind of short. Hopefully under 2 hours of closing arguments. And I do anticipate a ruling from the bench right on the spot. Let's hope for that. It could drag on if the judge wants to sort of take it under advisement and then issue his ruling later, but I don't think that's going to happen. We've certainly heard enough. I don't think anybody needs to go away and ponder this one, but we'll see what happens. Anyway, hi everyone. Good morning. Hi Rosie. Hi Jess. Thank you to the mods for being here. Man, this case is going to be rough on all of us going forward. If this is the kind of hearings we're going to have, oof. This is going to drag on forever. So special thanks to the mods who come to make sure chat keeps flowing nicely and peacefully. Thank you so much for being here. Hi, Sugar Butt. Hi, Kathleen. Stitchy Witchy. Cynthia Berg. How are you doing? As told by Thielen, good morning. Reverend Darlene, nice to see you again. I hope you all like the donuts. Good morning, Hot Scorpio, Grace, Carol's Cottage, Kenya Powell, Night Owl, Hopeful. I'm glad to see you, Hopeful. I hope you're doing well. We haven't touched base recently in Discord, but we'll get there. I hope you're doing well. All right, so a lot going on today. The rules, we have some rules in place for the chat. YouTube has come down pretty hard on any discussion regarding the events in DC. So we're not going to talk about that. Not in chat. I'm not going to address it. I'm certainly not going to show any more videos from Twitter like I did last time because I got smacked for that. So let's not do that. We're just going to talk about this case today, this hearing, and other fun stuff that comes up. Okay. Oh, goodness. So be kind. How are you? Leah Vogel, Debbie Wagner, Mary Ann. Oh, it's so good to see everyone here. All right. So I have reached out to Lori Hellis. You know that she is the criminal defense attorney that is doing the newsletter on this case. If she's around, I would like to have her on maybe after the hearing to talk about what we saw and what she thinks about it. That would be great. So if she's around, I will get in touch with her. If not, maybe her and I can plan a special live stream later in the week just to really go in deep about some of our questions about these proceedings. That would be great to do. So that is in the works. Hi, Carolyn. How are you doing? I hope you're doing well. All right, the hearing is supposed to start in approximately 28 minutes. So I wanted to come on early to talk about what we saw the other day. Because, man, I've been thinking about it a lot. My husband, as you know, is my sounding board. So he got to hear probably another 2-hour diatribe from me about what we saw during those 7 or 8 hours of that hearing. And I really have a pretty strong opinion about it. Right? I try to be very open-minded and see both sides and, get a very sort of diplomatic perspective of things. But I can't with this, not with this hearing. All I saw was Garrett Smith being very sketchy on the stand, contradicting his own statements, contradicting his own affidavit. They were woefully unprepared, right? Nobody had the affidavit open in front of them. They had different transcripts that they were reading from. I mean, come on. It was a 3-ring circus, Jess, absolutely. But it shows me that these defense attorneys, either they're not taking this all that seriously, or they really just think that their bluster is so powerful that they can just BS their way through something and convince someone to their point of view. I don't think that's going to happen. I don't. Judge Boyce does seem, we had a discussion about this last night in Discord. Judge Boyce did seem a little lax, a little easygoing, right? Far more than I would have expected from, say, Judge Edens, the magistrate court that we saw. I expected that Judge Boyce would have kind of shut this down a little bit, would kind of said, hey, why don't you just give your opinion on what you read? We're not going to break it down line by line. We don't need to. Or I would have expected Evans, the representation for Rob Wood, to say, hey, we're not here to philosophize. Give us your opinion, period. But also, nobody pointed out that they were discussing a situation that hadn't happened. All right, so one of the questions that I got after the hearing was, what's the difference between an interview, a meet and greet, and an interrogation? So let's go over that. An interview is done by law enforcement to gain information. In most cases, the person that they're talking to will have been Mirandized, especially if they're a person of interest. And that's usually recorded, and it's kind of formal. Okay, but that doesn't mean that person is necessarily a suspect, but it's a lot more formal than what we had here. That's not what happened between Summer and Rob Wood. This was not an interview. Okay, then we have an interrogation. An interrogation is done by law enforcement to elicit a confession from a suspect. Okay, that's not what happened here. All right, Summer was not under oath during the conversation. It was not formally recorded by law enforcement. It was not an interrogation. She was not Mirandized. That's not what this was at all. This was them saying, hey, hi, I'm Rob Wood. Oh, hi, I'm Summer. And Summer asking some questions about what she might expect going forward and getting to discuss, all of the happenings with the prosecutor who will be taking the case regarding the death of one of her family members. Okay, remember that Summer is Tylee's aunt, JJ's adoptive aunt. Okay, so of course she's a family member. She's having a discussion with the prosecutor. Nothing more, nothing less. It was not an interview. It was not an interrogation. Their conversation does not meet the definition of either of those two things, but that's what the witnesses were discussing. So I found that very jarring. Had this been an interrogation, which it wouldn't have been because Summer is not being accused of a murder, he didn't need to elicit a confession from Summer. But if it had even been a formal interview, like what Summer did later that day with law enforcement, okay, maybe they could have hashed it out a little bit more, but that's not what happened. So that's my big takeaway from that is they're arguing a situation that did not actually happen. All right, Ann Pena, thank you so much for the super chat. That's a cute sticker. How's it going? It's going pretty good over here. Thankfully, this is in the afternoon, so I got to be awake for a few hours before we start. All right, I'm checking the judge's website again in case it starts early. You never know. We have about 20 minutes before it begins. So I see that Lori Hellis is in chat. I'm glad you're here. If you have legal questions, tag Lori Hellis, tag me if I see it. I will ask her. Hopefully, Lori and I will get to sit down and have a discussion with you guys. I mean, I have some questions I would like to ask on the actual legalities of things, what we can expect going forward. So that would be a ton of fun to do. I did tell Paul. Paul is working again this morning, unfortunately, so he's going to have to catch up. But I said, by the time this case is done, when the trials are finished, the convictions are laid down, I'm going to be able to sit for the bar exam and never have to set foot in a schoolroom because, man, the research I have been doing is, it's a lot. It's a lot. But I want to know what's in these people's heads and what's going forward. Yeah, Lee, nothing was in front of a jury. Yep. So I think they've totally mischaracterized the conversation between Rob Wood and Summer. I hope that Rob's attorney, Evans, is going to push that point in his closing statement. I feel so invested in this case. It's like, I want to write the closing argument. Please let me do it. I'll be so upset if he doesn't point out some of the glaring things that we saw, especially Garrett Smith not actually answering the questions that were put to him instead of just using his word salad to talk himself around it. That really bothered me. Now, as you can see on the screen today, I do have Garrett Smith's affidavit that his declaration he put to the court regarding his role in all of this. And I'm really surprised. Maybe we'll see it today, but I'm surprised that right then during the hearing, Evans didn't pull this up and be like, look, do you remember saying this 2 weeks ago? Why did he not do that? I'm not sure. Maybe he thought it wasn't necessary because it was obvious enough. I don't know. Maybe they're just going to put it in their closing. I don't know. We're just going to have to wait and see, but we're going to find out soon. I am very, very interested to hear their closing. Do you know which party infiltrated or initiated the conversation between them? Judy, that's a good question. And we don't have a solid answer for that. At this point, it's he said, she said. Okay, we have Garrett Smith, who said under oath the other day that Rob Wood initiated the conversation. We have Rob Wood in his declaration to the court saying that Summer and Zulema reached out to him to have this meeting. So we don't know. We don't know. I would tend to trust Rob Wood's word more than Garrett Smith's, for sure. But hopefully they're going to iron that point out in their closings. Because to me, that there is a difference to me. If Summer was reaching out to them, if Summer said, hey, I want to talk to Rob Wood and what, that changes it in my mind as opposed to Rob Wood seeking out Summer. Why would Rob Wood do that anyway? I do believe that prosecutors talk to family members a lot, of course. I mean, that's common sense. But in this case, I'm not sure that happened. However, I would like some clarification of why all of this was going on in Arizona. Okay, what were they actually there for? Summer and Zulema, we know from the testimony, talked to law enforcement after they talked to Rob Wood for interviews. Okay, why? What were they talking to Arizona law enforcement about? This is not Idaho. This is Arizona. So this could be about Charles Vallow, could be about the shooting attempt at Brandon, it could be about Joseph Ryan, any of the stuff that happened in Arizona. Okay, so, but why was Rob Wood there? He has no jurisdiction in Arizona. Did he just go there to meet them? Was he meeting with law enforcement as part of his investigation? They all ended up in Arizona. Nobody's really talking about why. Okay, so we're just going to have to wait and see. They might not want to bring that up. So I don't think they have to, but that's my own personal curiosity. Why were they all in Arizona? And the other big thing that we heard that I think is really interesting is that Zulema has a use immunity deal. That kind of slipped into the conversation there, and I'm like, wait, what? Hold the phone. Let's talk about that. Sorry, reading chat. Believe that Rob Wood traveled with them, talking to everyone. This is reported somewhere. That Rob Wood traveled with Summer and Zulema? That I don't believe. That would be a little out of line, I would think. For sure. But Zulema Pastenes, Alex's wife, she married him. They were married for about 14 days before he turned up dead. And she has an immunity deal. Oh, he was traveling with law enforcement. Okay. All right. That makes more sense. It's like, why would he be traveling with Summer and Zulema? So Zulema has an immunity deal. Now, the use immunity deal means that she has information that she can give to the prosecutor that could be used against her. Right? She could be incriminating herself, or they could bring charges against her based on her information. So this deal means that they cannot or will not prosecute her for this information, but they could use it in the rest of the case. Right? So they could prosecute somebody else, but they won't prosecute her. The depth and breadth of this agreement, we have no idea. We haven't seen it. Nothing is formalized. We can't even say 100% sure that she has it, right? It was mentioned. Rob Wood's side did not dispute that comment, but we haven't seen anything formal yet saying she really has one. I wouldn't be surprised, given how quiet she's been this whole year. Right. The only peep we heard out of Zulema was when she was tracked down by a YouTuber at her house, which I don't think that's right, but that's just me. But they see, that's what I'm saying, Thalen, is they said doesn't mean as much to me as actually seeing it. All right. So we have to remember the people here in this hearing have said a lot of things. Okay. So saying something doesn't actually make it fact. But the fact that Evans did not dispute that was like, oh, interesting. I think if she did not have one, he would have jumped right up and said, no, she does not. Objection, whatever. Yeah, Garrett. Yeah, Garrett says a lot of crazy things, apparently. The other fun thing about the hearing, and this part was fun, was remember Samuel Newton, Dr. Fig Newton. his green screen. I went back and watched the video, and yeah, he is 100% using a green screen. And I'm just thinking, all right, you're doing this from home. Maybe you don't have a beautiful bookcase set up behind you or whatever, so you use a green screen. But it really, it just, the only word that came to mind was poser. You're a poser. You're pretending to have this beautiful bookcase behind you and have all your stuff together. Clearly you don't, you know. And that's just what I felt about their entire testimony. I felt that Samuel Newton was just BSing his way through it. I still can't believe that the judge accepted him as an expert witness. I didn't see anything he was an expert about, anything that any other law professor in the world wouldn't know or shouldn't know, you know. Lay, thank you so much for the super chat. She says, hi all, Awen, you rock. Thank you so much. You rock too, and thank you for being here. So yeah, it just, the whole thing was just, at the end of the day, I'm like, what a monumental waste of time that was. Because I say, if you're going to bring an allegation against someone for, say, unduly influencing a witness or coercing a witness, you better bring some evidence. Actual evidence. Did we hear any evidence? We heard the audio tape. Did that audio tape convince you, as a listener, that Rob Wood coerced Summer? No, not me. Did they have any other evidence of actual coercion or influencing or anything that they allege? Any evidence at all? No. They had two philosophical people on after that to philosophize about, well, maybe it could be this and it could be that, and oh, cognitive dissonance, and oh, GMAC, and da 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 da. I was like, stop. That's not evidence. Okay, that is not evidence. Evidence is, here is what he said. This is why, you know, of course they were trying to say this is why it's coercion because of all these weird psychology things. But that's not evidence. That was opinion. And yes, that's what an expert witness is for. They're allowed to introduce their opinion. All right, so it can be considered by a jury. That's not what happened. It's not what we saw. You know, it was a bunch of posturing, Brenda. Absolutely. So I have to date seen no evidence that Rob Wood coerced or influenced or intimidated or threatened or did anything else wrong to this witness. I also don't believe that she was technically a vulnerable witness. I mean, kind of, because she's family member, so technically, yes. But she's laughing and giggling through the whole audio. Did Summer sound upset to you? Did she sound threatened or concerned for herself at all? No, she did not. Maybe a little concerned for her sister, which she should have been. Her sister's kids were just found dead in her husband's backyard. She should be concerned about that, you know? That's kind of a concerning thing. But, yeah, man, how mad and polemic will Pryor get today? See what color he is. About to be purple by today. Oh, goodness. Yeah, the audio tape only showed that Summer was asking Rob Wood for information. They had no evidence, and they were waffling on and on. I agree. I think the bar for evidence for something like this, for removing a special prosecutor from a case, has to be more than, well, he said I wasn't qualified, Your Honor. Meh. Baloney. Sit down, Mark Means. That's enough of this. So I have to see what happens. Do you have a video or of Summer? I haven't heard anything. The videos that we know about Summer are just her interviews that she did on TV, basically saying there's no way Lori did this. Her appearing with Janice in a television interview where Janice even said, oh, this didn't happen because I heard from JJ on October 1st. Oh, really? Interesting. Stephanie Mertz, thank you for the super chat. The thank you sticker is adorable. And thank you for being here. I really appreciate the support. Both the great witnesses have books to sell. Yeah. Yes, they do. Judy McGuire says, Awen, Summer sounded like Lori when the cops came after Charles was shot. It was a nervous laughter, attempting to flirt her way out of trouble. She knows something. I agree. We did learn through this whole process that Summer attended Preparing a People event, didn't she say, with her mother and her husband to support Mel? Huh. All right. So Summer has a connection to Mel. That Mel, I would assume, would be Melanie Gibb, who took part in some of the podcasts, and she was very active in the preparing of people stuff. So is Summer far more involved with this cult-like aspect of this case than we thought? Yes, I think that's fair to say. Was she more involved with anything else that happened? Well, there is a rumor, and I don't know if this is 100% verified, that Summer was the one that called Alex and told him to go to Lori's house the night before Charles was shot. So does she have that kind of intimate knowledge of Lori and Alex and their plans and things? It's possible. It's possible. So, Summer should, consider being more careful. She did have the two interviews on TV. She did have that statement that she introduced after the children's remains were found. I found it incredibly self-serving and self-focused, and it was not pleasant to read that. So we'll see what happens. I would like to know right now if Summer knows that all this is going on. What does Summer think of them using her conversation with Rob Wood to try to get him thrown off the case? Is she behind it? Does she support it? Would she be like, no, don't do that. He didn't do that. Why wasn't Summer called? Probably because the defense could not call her as a witness for this, because she would say, no, I didn't feel pressured or intimidated at all. And they'd be like, oh, well, that's not going to help their case. So maybe that's why they didn't call her. But in that case, Rob Wood should have called her. Somebody should have talked to Summer and found out what she thought and gotten her on the stand. So, because her statement could have influenced this one way or the other. Yay, Sarah, I'm glad you made it. Welcome. Glad you're here. We're going to get started in about 9 minutes. So it should be soon. Just checking on Judge Boyce. No, I don't think there'll be any further witnesses called. Hot Scorpio, I think today is just going to be the closing statements by each side. I expect Pryor to be a little windy. And of course, Mark Means is going to want to have his say too after Pryor. And then we'll probably hear from Evans. And then I'm hoping the judge will make his ruling right from the bench, so we don't have to wait. But, stranger things have happened. No, I don't think the judge would intervene so far as to actually call a witness himself. I don't think it works that way. I don't know if he has the leeway to do that. Well, I don't think so. That would strike me as very strange if that did happen. But they did say the other day when they closed that there were no more witnesses. So should just be closing arguments today. There were a couple things added to the court docket for this hearing. Were there? Let me check. I haven't looked at that. Let me open that up. See what we got here. Oh, that's not the docket. I just have the notice. Cynthia, what were they? Anything important? So wait for Cynthia to get back to me. I have the court documents thing. I don't have the actual docket page up. Perhaps that they did add some more witnesses. Maybe Mark Means and John Pryor realized that they were in trouble. Testimony from Mindy Gee and something about Summer. Mindy Gee. All right, who is Mindy Gee? Let's do a quick Google. Mindy Gee. Well, it's either a graphic designer from Brigham Young University in Idaho. That's possible. Well, we're going to have to wait and see who Mindy Gee is. Because, man, I was not anticipating more witnesses. I am hoping that's not the case. Oh, good grief. Good grief. Eamon, do you think the recording was an attempt to set up Rob Wood? I honestly do. And normally I won't go in for conspiracy theories like that. But the fact that Garrett Smith kept changing his story about when the recording was turned on, his motive for recording it, his statements about why he produced the recording to Mark Means, all of that, it really makes me sound like he did this with a purpose. And the fact, the biggest fact is that Garrett Smith is going to be there under oath. I would say on the stand, but he technically was in his living room. But to be there under oath and say that he felt that this conversation was so egregious, was so terrible, right? Rob Wood just violated all the things, right? That he had to produce it to Mark Means and, to say, here, look what happened. But the fact, just the fact that he could sit there and say that, but he sat there during this conversation silent the entire time. He never once said to Rob Wood, too far, let's change the topic, or he never raised any objection, even though it was not a technical thing in that situation, to anything that Rob Wood said. He just let him go and recorded it. Right? So if he was so upset about Rob Wood influencing his client, he should have said something during the conversation. But he didn't. He let it go. So to me, that tells me he has an ulterior motive for producing this recording. If he was there solely to protect his client, he should have said something on the spot at the time it happened. Right, so that's a different motive in my mind. Did they walk into there intentionally with the motive to get Rob Wood to do something wrong on tape? Maybe not. Maybe not. But I think it was recorded possibly in the hopes that Rob Wood might do something that they could use later. Because looking at Garrett Smith and his disciplinary record, he's whatever. So all of that combined makes me think in a very conspiratorial way that this was a setup. But that's just me, because we tend to see conspiracy somewhere where we shouldn't. And perhaps I shouldn't see it here, but that's what I feel, because he could certainly have pulled Summer right out of that interview or conversation. It was not an interview. He could have pulled her right out. He could have shut it down. He could have stopped it on the spot in a heartbeat, but he let it go and kept recording. So, there you go. I don't like that at all. That does not sit well with me in the least. So, let's see. Let me check on chat. What's going? All right, Lori Hella says she does not think it was a setup. That's a conversation I would love to have with you, Lori. I want to know why. What am I not seeing here? What am I misinterpreting? Because certainly without a legal background, to me, it looks something very different than it could legally on the surface. So I would love to talk to you about that. Rob Wood did not tell her anything that wasn't pretty obvious. Also only told her the truth. So how is that wrong? It could be wrong. Even telling her the truth could be wrong. Because it could, it's really, really gray. And certainly that's what Dr. Davidson and Dr. Newton talked about for hours and hours. I don't think that was his intention. But then again, this is my interpretation of what Rob Wood said. Okay, we're all interpreting this conversation our own way. I think he sounded compassionate and honest and was really trying to say, hey, this is kind of a big deal. This isn't just a little, we're mad at her because she didn't show up to court when she was supposed to deal. This is a big, giant deal. All right. And perhaps that right there, him letting her know that this was a big, giant deal, could have been a violation in some way, shape, or form. I don't personally think it was, but, I could see where maybe they want to argue that. But once the meeting was recorded, it was a gotcha moment. They would have attacked Wood no matter what he said. That's true. That is true, Kenya. And interestingly enough, we're sitting here talking about a rather pleasant conversation that Rob Wood had with a family member, okay, about the children whose deaths he is prosecuting. And that's big enough of a deal to have days worth of hearings before the judge. How come it's okay for Mark Means to actually intimidate witnesses on his Twitter account? How come that's okay, but this isn't? This was done privately. This was technically off the record. This was not a formal interview, and Rob Wood was polite. But the stuff that we've seen from Mark Means on Twitter, the picture of the rats, calling out Melanie Gibb and David Warwick, like, you know more, you better start talking, going after Kay and Larry Woodcock, and alleging that they were nefariously recording this hearing and that law enforcement pulled them over and removed their mics. That didn't happen. That did not happen. So not only is he outright lying about people involved in the case. He's alleging that they did terrible things, have nefarious purposes. That is okay, but this conversation is not. I find that very difficult to believe. Very difficult to believe. And I would have hoped that Rob Wood would have come back with a slap about that. But like, hey, and who knows? Maybe he will file the same type of thing. He could file a motion to disqualify for them intimidating witnesses based on Mark Mean's Twitter account. I think there's a lot more evidence in that case than we have here, for sure. So I find the hypocrisy of this filing appalling. The time that he's spending with the court to hear this issue is very frustrating. This is not what I want this case to be about. It's not about a pissing contest between attorneys. This is about getting justice for these murdered children. And I think Mark Means and John Pryor have lost the plot. Granted, it's their job to defend Lori and Chad, but this goes far above and beyond that, I think. Oh, sorry, so thirsty. It's hypocritical. Wait, is that Chinese food?
Yes.
What kind?
Yours is in the kitchen.
Oh, I have some in the kitchen?
Yeah.
What did I get?
You got the lo mein one.
Roast pork lo mein?
Yeah.
Okay, cool. I'll have that later. Thank you. Husband comes home from lunch for work and often brings food, although that's got to stop. Monday we start keto. But today I'm having roast pork lo mein again. Yeah. Yep, more Chinese food. Chinese food is one of my vices. Pryor owns Chad's house now. Yes, he does. Yes, he does. And as told by Thielen, has a... Oh, there we go. I couldn't hit the button. Sometimes when you guys post things, YouTube will hold it for some reason, and we have to approve it. And for some reason, it would not let me click that approve button. So Jess says she is extremely... I'm sick of extremely comfortable Zoom hearings. That's a really good point. We have a few more minutes. So this is something that Jess and I and a couple of the other mods were talking about in Discord last night. What we saw, right? Remember Garrett Smith is on the stand and there's a knock at his door and he gets up and goes and answers the door. Okay, not on the stand, but he was whatever. He was under oath testifying. If you're in a court of law and you're on the stand testifying, you don't jump up to go answer a door. Or, excuse me, I'm going to run to the potty. You stop. You ask the proceeding to stop. You get permission from the judge. You do all this stuff. Just jump up and answer the door in the middle of a hearing. It's like, what? And the other guy, apparently, to me, it looked like he was in his bathroom with a green screen. Dogs barking, kids running, doors opening. It's like, this is weird. Right? It's too comfortable. Okay? It's very comfortable to sit in your own living room on your couch or on your bed or be in front of a green screen and testify in a hearing like this. Because when you go to court, the seriousness of it is impressed upon you. You have to pass through security. There are bailiffs. There are bright lights. You're on the stand. Everyone's looking at you. There's the judge with his big giant desk. It's very almost intimidating itself, a process to go through. You don't have that when you're sitting in your living room, right? The seriousness of what's happening is not imparted upon you when you're sitting in your living room. And it is starting, so let me share my screen. 1 second. All right, here we go. Let me turn it all up.
State of Vallow versus Chad Daybell in Fremont County, case CR 22-20838, State versus Lori Vallow. Representing Mr. Daybell is Mr. Pryor. Mr. Means represents Ms. Vallow. Mr. Troy Evans on behalf of the prosecutor. Counsel, I would note that the defendants are not appearing today. I asked this before, but I'll do so again. Mr. Pryor, first, is it your client's intention to waive her right to an appearance at this? I'm sorry, his intention to waive his right to an appearance at this hearing today?
It is his intention, Your Honor, yes.
Okay, and Mr. Means, have you also discussed that with your client, and is it her intention to waive her right to appear for today's hearing?
It is, Your Honor. Thank you.
All right, thank you. We are conducting this hearing by Zoom, as we did before. We are recording it on the Zoom software. We also have our court reporter here today. We're also using the FTR recording system out of Fremont County, and the parties are appearing by Zoom. In addition, the hearings being live streamed on the court's YouTube channel to allow access for the media and the public to this hearing today. This is a continuation of the hearing we had on January 6th, whereby the defendants have both filed motions to disqualify the prosecuting attorney. We took evidence at that time, and I allowed additional time for preparation of closing arguments. In the interim, counsel, I just want to discuss procedurally where we are. I received today a motion entitled a motion for testimony of Summer Shiflett. That's been filed by the state. It was filed this morning. I also would indicate I did receive additional briefing from the parties, and quite frankly, I just received those on very short notice here, and I'm probably going to need to take a bit of a recess to review through those written submissions prior to hearing the closing arguments. But I think we should first go through the issue of the state's motion. There was a request in the motion for an expedited hearing on that. I'll ask you, Mr. Pryor, did you receive a copy of that motion?
I did not. And Judge, in addition, I filed an objection to Ms. Gee's affidavit with the court this morning because I received the state's brief this morning, late this morning, as well as their alleged, or not alleged, excuse me, the affidavit of Ms. Gee indicating some representations of what Summer Shiflett said.
Okay, and that just, Mr. Pryor, that does relate to the motion. So are you indicating you've not received? This was filed at 9:17 a.m. It's entitled Motion for Testimony of Summer Shiflett. Have you seen that?
I have not.
Have you seen the motion, Mr. Means?
I have not seen the motion as of yet, Your Honor.
Okay, well, I'm going to go ahead and take a recess at this point. Let's go off the record. I just want to discuss procedurally where we are with counsel on these late filings, make sure everyone's had an adequate opportunity to review the filings that have all been filed today, including the court. And it is still my intention to go through with these hearings today and hopefully be able to get through everything and bring this matter to a conclusion today. But we do need to allow adequate time for that. So at this point, I'm going to call a recess to the hearing. I would ask that Madam Clerk arrange for a breakout room for the state and both defense attorneys and me. I'll have actually Ms. Gibson, the court reporter, also there in the breakout room. And I just want to discuss the logistics of getting these motions cross-submitted so all parties are aware of what's been late filed in the case. So that we'll take a recess at this time and wait for the breakout room to be available.
Thank you, Your Honor.
Oh, well. All right. First of all, I'm looking at the courthouse. I do not have a copy of this affidavit from Miss Gee. If anyone does, Cynthia, if you see it, can you get it to me real quick? Let me check Justin, see if he's got it. Let's see if we can find this and read what the heck it's about. I would like to know. All right, so Miss Gee, apparently we're going to have, or they're going to argue for testimony from someone named Miss Gee, who is allegedly going to talk about what Summer Daybell said. Or not Summer Daybell, Summer Shiflett. I'm not sure how I feel about that. That feels a little strange. Let's see. Let me get to my tweet deck. See if we can find this document. Yeah, Cynthia, if you have it, please let me know. You can message me on Facebook with a link or something. Let's check Justin. He's usually got all this stuff. Nope, nothing yet. All right, so nobody apparently has this document yet. Right, I'm going to keep looking for stuff, see if we can find it. I would like to know what the heck this is. Right? Who is Miss Gee? Where does she come from? What is her connection to this? What is she going to testify to? She's going to testify on top of Summer or on behalf of Summer? Like, what? Isn't that hearsay? Although I assume in a setting like this, hearsay might be admissible. I don't know. Lori Hellis, what do you think about that? Would Miss Gee, whoever she is, be able to come in here and talk about what Summer said to her? Yeah. Is she law? We have no idea. I have no idea who Miss Gee is. Never heard the name before. I do believe that if she was going to talk about what Summer said, that could be hearsay, but clearly the rules, hearsay rules, would be different in a situation like this than in a normal trial. So maybe it's admissible. I don't know. Rob Wood apparently filed this. She's here on behalf of the state, they said. So, very interesting. Even though it may technically be hearsay, hearsay is applied differently in different types of settings. Okay. Someone posted the list of new stuff just showing that Miss Gee and Summer were added today. Okay. But not the affidavit. All right. I'm going to keep checking. Yeah, if we could get, like, if they're going on recess to read this, then, we need to read it too. Hello. Give us this filing. I still see nothing on the court website about it. Of course, they take a while to update the website with the filings. Amended notice of remote hearing. We already had that. Come on. Let's see. Yeah, all I have is that the last thing was the filing for the amended notice of the hearing. We already had that. So, anyway, that's going to be interesting. It looks like this is going to be another long day. It really does. Man. Yeah, I was so prepared last time that now I'm just like, what? New papers? I don't have new papers. What do I do? I do not like doing these things unprepared. I really don't. Like, I want to have all the documents in front of me and know exactly what's going on so we can talk about it. But we don't have this. So what is she going to talk about? I have no idea. No idea. However, since it was submitted by the state, we can probably assume that she's going to be saying something. Okay, thank you, Nicole. I'm getting messages from people who are watching all the feeds. Miss Gee is the witness Rob Wood brought in the room while he talked to Summer and Zulema. This is so Wood can't be called as a witness. Interesting. So, yep, Miss Gee is a state witness, been called by the state. As an office assistant in his office. Okay. All right, well, that's good. Certainly, if she was there as a witness to this conversation, then she should be able to testify to that without it becoming a hearsay issue. I would assume. We'll find out. I'm sorry if you hear the bings in the background. I've got messages going off. We are now on a mad hunt for this affidavit. We should just tweet at Mark Means. Where is he? Let me see if he'll give it to me. Means Law. Let's see. Where are you, Mr. Means? Let me tweet at him. Means how much? Come on, just tweet at him. Why is this so difficult to send a tweet? At Means Law. I can type. Sorry for the typing noises and stuff, but can you link to the PDF of the affidavit submitted this morning so we can read it while you're in recess? Somehow I don't think he's going to give it to me, but no hurt, no harm in asking. Oh man, I did. I just tweeted him and asked him if he'd give me a link to the PDF. So, because I need to read this. It's very hard to talk about a hearing that we're having when we don't have the paperwork in front of us. That's not cool. You know, they know we're watching. They got to give us this stuff. You know what I'm saying? All right, so, yeah, he should send me the link. There's no reason not to. Yep, I've got Justin on the line. I've got Mark Means going. If we can get a public copy of this, we'll have it on the screen as soon as it pops up. If I remember correctly, Miss Gee's name was mentioned on the certificate with the doctor that was doing the models. Okay. Interesting. Nate might have it. Yep, let me tweet at Nate. Oh, we got some noise.
We're going to take a break for about 15 minutes for the attorneys to review all the documents that have been filed. Judge wanted me to let you know.
Okay, thank you.
Okay, well, that wasn't exciting. Maybe I can tweet her, the court reporter, and be like, link me to these documents, please. Oh. Yeah, Ashley, I know. I do talk a lot of crap about Mark Means, but, you know, I'm still not above asking him for the documents. Why not? You would think he'd want us to have them. All right, the documents are not published yet. All right, that's what I thought. I have the court website open. Anything that's published will go right up there, and as soon as they're published, we can get them. It takes the court a while. They get the filings, they put them through all the normal processes, and it's usually a couple hours later that they're actually posted for us to see. So I think we may just have to wait. I'm not sure who she was talking to. Court reporter was talking to somebody. Yep, now's your chance to let the dogs out. We have 15 minutes. Go ahead, go to the bathroom, get a snack, let the dogs out, because we've already been here 46 minutes and we have gotten nothing yet. But we shall see. We're talking again. Every time noise comes on from the courtroom, I jump. Like, what? Are we back? But no, we've got 15 minutes. I have no response yet from Mark Means. Apparently, he must not be watching his Twitter account real close today. Oh, goodness. All right, so yeah, we have the motion to compel, motion for testimony of Summer Shiflett, affidavit of Mindy Gee, objection to defendant's specific request for discovery, and supplemental affidavit of Mindy Gee. All of those have been filed. But we have nothing. We have nothing to see yet. We just know that they were filed. So there you go. We're just gonna have to wait. Justin is watching. He's tweeting everything. As soon as they're publicly available, we'll know. So a new witness testimony by Mindy Gee is her name. Was apparently with Rob in the meeting. That's good. That's good, because I think that they just mischaracterized this meeting. And certainly if there was a witness to it and someone else in the room on Rob Wood's side, that would be good. That would be excellent. We got 25 tabs open on my Chrome. I don't want my Chrome to crash and lose the live streams. Got to be careful. We knew Wood went in there with someone because this, having a witness, is allegedly what made Garrett feel it would be adversarial. Oh, that's right. Good point, as told by Thielen. And of course, we have Pryor objecting to all this stuff because he hasn't had a lot of time to review it. Well, you know, tough. But I am concerned that the judge may come back and they may reschedule this if they need more time to go over this information. So, you know, it's quite possible that we will not get resolution for this today. I hope we do. I hope they have time to read it, get prepared, and come back and hear the arguments for or against. But I would like this done because we need to remember nothing is going to proceed in this case until this issue is sorted out. So I want this done today. Now, about this Chinese food, Just Nestle, where's yours? What kind would you like? You say the word, and I will have Dave Uber Eats it to you. And have some Chinese food. I'm just having some pork lo mein. I'm not having it yet. I'll wait till the lunch break. But see, we cannot reschedule. Seriously, there are other things to focus on, like the children. Yep, got Kay. I agree. Oh, is Kresha here? There she is. Trust me to say this is not going to be a positive thing for Tylee and JJ. Trust me. Oh, this is, oh, goodness. I was like, wait, what? This is going to be a positive thing for Tylee and JJ. Thank you, Kresha. A word of calm and serenity from the family in this case. We're all panicking because we don't know what's happening. We don't want Rob Wood removed. Remember, Kresha has, she told us yesterday that she met with Rob Wood. And didn't you say he came off as genuine as he seems? He is genuine and compassionate as he seems. And that's one thing I said the other day. What I heard from that recording was that he was honest with Summer. And sometimes the truth does hurt a bit, but he was compassionate, and it's just like, that's who this guy is. I don't think for a second he's up to anything nefarious at all. And I think all of us are collectively furious at the defense attorneys for doing this right now. I would be the first one to say, even if I liked an attorney, that if he did something underhanded and slimy, I would be the first one being like, get rid of him, start over. And I've done that in other cases. In this case, I just don't see it. I don't. He's a good guy. So, something's in the air. You're having Chinese too, Zuzu? Awesome. And Katie Gill's having Chinese. Apparently, this is the day for Chinese food, so let's do it. Ann Pena, thank you for the super chat. Ann says, even when I have a doctor appointment, I take care of all needs. It's respect. Ban the one guy did not have it. Yep. Definitely. So yeah, I cannot wait to hear what's coming. Remember during the hearing the other day, a lot of us, especially me, I was feeling like, why is Evans just sitting there? Why aren't they objecting? Why aren't they fighting this? Why aren't they saying, stop. He just contradicted himself. Stop. They're not using the right documents. Stop. He didn't object to any of that stuff. And I was like, what are you doing? Come on, jump up and down. Perhaps they didn't need to do that because they knew they had all of this. And maybe they didn't file it right at that time because hoping they wouldn't have to use it. Rob Wood seems to keep everything back until he needs to use it. He's not going out on, sucker punches. He's not doing that. Even with the preliminary hearing that we saw for Chad, he brought out only enough information to prove those conspiracy charges. Nothing else. He kept everything else back because it was not the time or the place for it. And he only used as much as he needed to secure that the hearing would go to trial. My husband is leaving. Are you going back to work?
I am.
Okay, have fun. Come say goodbye. You're going to leave without giving me a kiss goodbye? That's illegal.
Is it? Oh, I see.
I'm going to file a motion to have
Are
you
you?
restrained
Oh,
until you give me a kiss goodbye.
I see.
Yeah.
This is
Now you owe me another bottle of champagne. I know we can't really afford this. My champagne habit is becoming a problem. A serious problem. Yeah. I don't think they sell champagne at the Chinese place, Jess, but if they did, we'd be there probably a lot more often. Rob Wood is a professional and behaves that way. I agree, Miss Wheelassie. We have seen nothing unprofessional from him. Even as high profile as this case is, you don't see tweets from Rob Wood about it. You don't see this stuff. He's being very low profile, very professional. His focus, as he has said, he's gotten worked up. We've seen Rob Wood almost in tears in some of these hearings talking about the children. And I believe that he really feels that. So, yep, I did. My husband brought me home some roast pork lo mein again for lunch today to get through the hearing. So, hi, Pits and Beagles. How are you? I hope you're doing well. All right, let me refresh all the court websites and stuff so you can find this affidavit yet. Nothing there. Nothing there. Let's check the tweet deck. Let's check Justin. Justin does not have them yet. They're still not published. Oh, man. All right, so the things that we have, let me put this on the screen while we wait for the court to come back so you can see what we're dealing with here. Chrome tab, tweet deck, this. All right, you can see that on your screen, I think, if I've done it right. Let me check 1 second. YouTube is a little delayed from my live. Okay, there we go. This is what we have right now to deal with. All right, these are coming up. So let's talk about what we're seeing. First, we have declared motion to compel. I have no idea what that is. Motion to compel who? Maybe to compel a witness? I don't know. Next motion, Vallow. Motion for testimony of Summer Shiflett. Good. I want to see that. Affidavit of Mindy Gee. Who is she? What does she have to say? We don't know. The Vallow objection to defendant's specific request for discovery. Interesting. To me, that sounds like Rob Wood is objecting to Pryor or Means's asking for something specific in discovery that he doesn't want to give to them. Maybe he doesn't feel the need to. And the Vallow supplemental affidavit of Mindy Gee. So that's what we've got on tap as soon as all of this happens. So apparently it's going to be a really long day if we're going to be going through all this stuff. So we're just going to have to wait and see. All right, we're back waiting on the courtroom. Nothing's happening yet. Let me check chat. What's going on in chat? We don't want to see 10 pounds of makeup Summer again. Well, I think the best thing for you, the best thing for us would be to see Summer on the stand, even, this virtual stand, and say, no, I did not feel coerced, intimidated, threatened, or anything else. Period. No, nothing Rob Wood said changed my potential testimony or anything like that. He had no effect on what I might do or not do. That would be the best thing. I'd like to see that. Gina, thank you so much for the super chat. Why did Pryor object if he didn't get it? I don't know that Pryor did object. Well, he objected to something. I'm not sure what he objected to exactly. So we're going to have to wait and see on that. I think his main objection that we heard before they went to recess was basically he just got this right now and he doesn't know what's going on. He needs some time. Maybe. I don't know. We'll see. But they should have about 4 more minutes left before they come back. Yes, court normally would end at 5 p.m., but given the situation that everyone's home lounging in their pajamas, so to speak, maybe they'll go longer. I don't know. Ashley says, Summer will say it did intimidate her because if you listen to Mr. Smith, that he had asked his client if she was okay with him going forth with his testimony. Oh, he did say that she was okay with it? Interesting. Okay. Well, I don't think that the state would call Summer if Summer was going to say that she felt intimidated. Or it doesn't seem like something they would do unless Mark Smith said that because he lies like a rug. Wouldn't it be something if Summer gets up there and be like, you know what? I didn't know he was recording it. I didn't know he was using this as a motion to try and get rid of Rob Wood. I had no idea he was doing any of this, and I don't agree with it. Wouldn't that be something? Because then you've got Garrett Smith on perjury, because Garrett Smith said a lot of stuff, didn't he? Yeah, if they compel Summer's statement, Mindy Gee may not be needed. Wonder why the state wasn't calling witnesses. I did too, Lorianne. I thought that was strange. Given the witnesses that we saw from the defense, I was like, surely they have somebody a little more nous about them to get on the stand. But and they said, nope, we're ready for closing. I was like, okay. There's no telling whether Garrett was honest with Summer when asking if she was okay. Yeah, Miss Vilas, he could have made that whole thing up. He could have misrepresented what Summer said to him. The whole thing. Garrett Smith does not seem honest to me. Now, granted, we're not a jury, and it's not a jury trial, but if we were, all right, if we were members of a jury listening to this right now so far, what would you think of Garrett Smith's testimony? Right, because they would have put his affidavit forth, so we would have read that. You would have heard what he said, contradicting all of that on the stand, contradicting his own testimony while he was on the stand. Would you be thinking that Garrett Smith is really on the up and up? No. And remember, part of being a juror is determining who you believe and who you don't. That's part of it. So if this is the way the defense is going to conduct the trial, they're in for some trouble. So that is my unprofessional opinion about that. Garrett Smith has been reprimanded on several occasions. Yes, he has. He definitely has. You know, my bottom line for not trusting him is that he recorded this conversation and cannot tell a straight story about whether he let them know he was recording it, when he started the recording, where the recorder was during the proceeding. He can't tell you the truth about that. So that's a problem. Someone says they think Guy is the deputy or person that went into the room with Wood during the recorded interview. Okay. That's fine. That's good, because then she will have her, another witness to Rob Wood's side of the story. But man, when this stuff gets down to he said, she said stuff, I do not like it. Let me have a drink here. He lied and was less than truthful during his interview. Yep. During his testimony. He definitely was. All right, so best guess. If Summer testifies today, what is your best guess of what she's going to say? I'm going to say, because she's called by the state, that she didn't know it was being recorded. She was not informed by Garrett Smith. She was not informed that they were going to be using this in this motion to get rid of Rob Wood, and she did not feel intimidated. That would be my guess. Now, we're dealing with Summer Shiflett, Summer Cox Shiflett. So, oh, this is just so messy. The whole thing is messy. Okay, I have a photo of Mindy Gee. Mindy Gee is an associate. Oh, all right, here we go. Let me share this on the screen. I think we have time before court comes back. Give me 1 second. We now know who Mindy Gee is, so let's talk about that. Okay, this is her picture. That's Mindy Gee. She's an associate attorney. Mindy Gee is an associate in the corporate litigation and counseling practice group. She is a graduate of William & Mary Law School, and now court is back, of course. All right. Sorry about that. We'll go back to her later. Let's go back to the court stream. Full screen, StreamYard. Okay, I think they'll be back in a second. I'll mute myself as soon as they start. Sounds like a motorcycle or truck. Oh. Yeah. Who thought we would need a drink this quickly? Right, everyone's coming back on the screen, except Mr. Mark Means, who's always late getting back to these. Huh. Yeah, Antler Boy. Oh. Someone's going to say the talk about the LDS stuff wasn't offensive. Quite possibly, yep. Yeah, Means is busy replying to my tweet. Oh, that would be epic. Oh, man. All right, I've got to close all my other tabs, make sure this doesn't crash. Yeah, we're just waiting on Mark Means. The sound from the courthouse is muted. I'm not muting anything. They've just muted it while they sit and wait for Mark Means to decide to rejoin the party. Because, John Pryor always looks grumpy. Always. Even when he's smiling and laughing, he looks grumpy.
Let's see, do we have Mr. Means, or is he still on break here for a moment?
Your Honor, I'm here. I'm sorry. Let me start my video.
Okay.
Good grief. All right, I'm going to mute. Here we go.
Actually, Your Honor, it's saying I'm unable to start the video. I think I'm going to log out and try to re-log back in if that's okay.
That's fine.
Can you hear me, Your Honor?
I can, Mr. Means, can see you as well. Okay, we'll be back on the record then. Cases CR 2220-755 and 2220-838, State versus Chad Daybell and State versus Lori Vallow. We took a recess for the parties to review and receive these additional pleadings that have been filed in the case. I believe the parties have all had an opportunity to now review the pleadings. Mr. Means, did you receive a copy of the state's motion for testimony of Summer Shiflett?
I did, Your Honor.
And Mr. Pryor, did you receive that as well? You're on mute, Mr. Pryor.
I apologize, Judge. I did receive all of the documents, Your Honor. Thank you.
Okay, thanks. I appreciate you taking a moment for the housekeeping issues. Understanding we've had a lot of things filed here in a compressed time frame. And at this point then, I do want to take that motion up. It was requested to be done on an expedited basis, and as I understand, it may have a relation to the hearing we're determining today, so I think it's appropriate to hear that first. I would note that in addition to the motion, there was an affidavit of Mindy Gee and then a supplemental affidavit of Mindy Gee, which I believe counsel has seen as well. There was also an objection to the affidavits filed by Mr. Pryor on behalf of Mr. Daybell, asserting that they contain hearsay. So Mr. Evans, if you'd like to present argument on your motion for testimony of Summer Shiflett, I'll hear that at this time.
Your Honor, thank you. And it's just argument. Your Honor, as the court, I know the courts probably haven't gotten around to look at our brief, but motions to disqualify are viewed with caution. And when it's not dealing with current or former clients, there's heightened scrutiny that needs to be applied. And I've cited the case for the court on that. Witnesses are the most important aspect of our cases, and that's because they perform the sacred duty of assisting the court to discover what the truth is, and frankly, to assist all of us. This is why before they even speak in court, they need to affirm under oath that they're going to tell the truth. Where we've been the last few days, Your Honor, the defense wants the extreme remedy to remove Mr. Wood from this case. They claim he's been coercive, influence, coached, and this all has to deal with Summer Shiflett and in his meeting with her on October 1st of 2020.
Your Honor, if I may, I apologize. I think it has to be said that we're arguing the motion for the testimony of Summer Shiflett. They have cited one rule in their motion, and we are well beyond that one rule. It attempts that they're trying to backdoor in additional arguments for this motion. And having failed to cite this, I don't think that's proper before the court.
I concur with Mr. Means, Your Honor.
Okay, let me address that, counsel. We are obviously still going to have closing arguments on the motions to disqualify the prosecuting attorney. We've got a narrow issue before us on what's styled as a motion for testimony of Summer Shiflett. And in reviewing the motion, Mr. Evans, I will just read directly from it that you've indicated that the motion is made pursuant to Rule 4.2 of the Idaho Rules of Professional Conduct, and you're requesting that this court contact and hear testimony of Summer Shiflett. So I'd just like you to confine your arguments to the narrow issue of whether or not this court should contact and hear testimony of Summer Shiflett, and if so, when would you be requesting that that take place?
Your Honor, very good, thank you. Once Ms. Shiflett, so the history on that, after our hearing a couple of days ago, everyone knows Ms. Shiflett called the prosecutor's office
Judge, I'm going to object at this point. I've filed an objection to Summer Shiflett's affidavit being considered in this particular case. If Mr. Evans would like to cite the case and the case law and the statute that grants the court authority to hear Ms. Shiflett, by all means go ahead. But if he's going to regurgitate things that have happened that are clearly inadmissible, we're going to have a problem. And I'm going to strongly oppose this going down this path at this point.
I understand, Mr. Pryor, and I think to correct you, it was the affidavits, not of Summer Shiflett. She hasn't submitted any affidavits.
Mindy Gee, Judge.
Mindy Gee, yeah. And there was a objection made based on hearsay, and I am going to consider that objection and hear and rule on that before we get into what Ms. Gee has to say in her affidavits or what Ms. Shiflett is alleged to have said to Ms. Gee. So I would like to hear, Mr. Evans, there's an objection to those affidavits requesting the court not consider them based on hearsay. And what is your response to the hearsay objection?
Your Honor, it doesn't go to the truth of the matter asserted. Also, she just wants to talk to the court. That's the bottom line.
Who does?
Ms. Shiflett.
Your Honor, I've got to object to the representation of what Mrs. Shiflett has allegedly said to this Mindy Gee, now attempting to come in through Mr. Evans. I mean, we now have multiple levels of hearsay here. And quite honestly, this motion it was identified 10 to 14 days ago. Forgive me, I don't remember the exact date. Mr. Evans, in his own argument, has had plenty of opportunity to attempt to contact Summer Shiflett or even opposing or Mr. Garrett Smith. And it doesn't appear that there were any efforts to do that prior to the hearing 2 days ago. And so again, if we're going to make statements regarding what somebody said to somebody, again, additional problems.
All right.
And Judge, if I could just add that even if Mr. Evans wants to suggest he couldn't go to get a hold of Ms. Shiflett because of Mr. Smith, we have a subpoena process. And I would assume that 2 lawyers from the state would understand that they have every right with 2 weeks notice to subpoena any witnesses that they feel would help their case. Instead, what they did, Judge, is they provided no evidence whatsoever. And at the conclusion, are attempting to do this backdoor tactic, the same kind of backdoor tactic that we had one of the other expert witnesses talk about.
All right.
Bringing,
We're beyond the scope of a hearsay objection as well. So I want everybody to keep in the confined scope of a hearsay objection. Mr. Evans, you indicated it's not being offered for the truth asserted, but you are turning around and then saying, well, here's what someone told Mindy Gee. So I just need to know, do you have a specific exception to the hearsay rule which would allow consideration of these affidavits?
Your Honor, thank you. We're just looking at Rule 803. I think under 1, the present sense impression, so a statement describing or explaining an event or condition made immediately after preceded, and then as well as the catch-all, the other exceptions, looking at the trustworthiness of it, the factual basis of it, and then the probative point of it. So that's under Iowa Rules of Evidence 803.
All right, I'll allow a response to the argument that there's an exception that applies here under 803.1 in the catch-all. Mr. Means first, and then Mr. Pryor. And counsel, please, again, we're only on an issue here of, do these affidavits contain hearsay? You'll have plenty of time for other argument on the other bigger issues here, but keep it confined to that. Mr. Means, what's your response to the state's indication that there's an exception that would apply?
Thank you, Your Honor. And looking at these affidavits, there's not a lot of difference between the two of them. I think we do have a problem where we have hearsay and then we have double hearsay. And I think the analysis would have to be provided at both levels. I think the present sense impression does not apply, to be quite frank. And trustworthy, I think we have an issue because I don't even think these could be characterized as midnight affidavits, considering this is after the fact of the hearing. This is more of the morning after. So I think trustworthiness is an issue as the prosecution attempts to be coming kind of in a backdoor manner to address what should have been addressed at the hearing 2 days ago.
All right, thank you, Mr. Means. Your response, Mr. Pryor.
Judge, I'll start with the last one, which would be the catch-all, which is usually a tactic used in court to try to get something in when there's no other reasonable reason to get it in. So that's not applicable in this particular case. Trustworthy is not applicable in this case. That's for the court to gauge whether or not a document, and really quite honestly goes to more authentication. The present sense impression, Judge, that's taught in first-year law school, and that's an impression that someone gets upon observing a startling event. And quite honestly, Judge, there's been 14 days for Ms. Shiflett to do this. To suggest that after 14 days we've had a startling event that warrants her to come forward with something is ludicrous. So quite honestly, I can't even, by the minimum stretch of my mind, imagine any situation where present sense impression would even remotely apply to this. They are grasping. And now I know why they're grasping, because it took a significant amount of time for them to come up with a response while we patiently waited for them to address the hearsay issue. This is hearsay. It doesn't come in. And Judge, again, I guess yesterday I was temperate and I was upset, and I'm still that way. And I want to apologize to the court for that, because I don't mean to be, but this is a very disturbing situation, and to suggest that it's present sense impression is just completely ridiculous. And again, I apologize to the court for my temperament.
All right. I've considered the objection filed. There's an affidavit of Mindy Gee. There's also a supplemental affidavit of Mindy Gee. There's been an objection made that portions of those affidavits contain hearsay. I've reviewed it. The statements of Mindy Gee about what she did in terms of taking a phone call are not hearsay. That's her own testimony in the affidavit. It's sworn. However, these statements as to what Summer Shiflett told Mindy Gee, that Mindy Gee is now telling the court, is clearly hearsay. And so the court will not consider and will strike those portions of both affidavits that pertain to any statements made by anything that Summer Shiflett did say. So that'll be my ruling on those affidavits. All right, with that in mind then, Mr. Evans, would you continue with argument in support of your motion to allow the testimony of Summer Shiflett?
Your Honor, yes, we've found no rule for the court to disallow further evidence in a hearing. This is not a trial. This is just a hearing. There's nothing that says the court has to follow timeframes, especially if the result is a manifest injustice. We believe that the record that the court's trying to rely on is going to be entirely empty of the facts that go to the heart of the issue. And the heart of the issue for the court is, did Mr. Wood's communication with Ms. Shiflett, were those influence, and that led to her changing her testimony to law enforcement. So we believe that her testimony is absolutely crucial. She is the person that we're talking with in all of these matters, and she wants to testify, and we ask the court to allow her to do so.
All right, thank you, Mr. Evans. Response to the motion, if there's an objection, Mr. Means.
Thank you, Your Honor. Again, I think the argument is well off of what the motion that is before the court. The only, if we could even call it a rule that applies, is they cited Idaho Rule Professional Conduct 4.2 entitled Communication with Persons Represented by Counsel. There is nothing express or implied in that rule that allows the court to entertain this motion. There's no attempt to cite any kind of criminal rule or even an implied civil rule that might be duplicated in the criminal rules here. So we're limited again to the argument of, based on the rule 4.2, communication with persons represented by counsel should justify them in bringing this morning after motion. We've been down this road before, Your Honor, when we had a motion for a judicial protective order in a rule in the Idaho Rules of Professional Conduct that did not apply. It's the same attempt by counsel here to attempt to do the same thing, which is inapplicable in their request and the remedy in which they're seeking.
All right, thank you, Mr. Means. Your response, if any, Mr. Pryor, please.
Judge, there was a hearing set. I believe Mr. Means disclosed his witnesses and his exhibits. I disclosed my witnesses and my exhibits. Mr. Wood, at the time, through his counsel, chose yesterday at a trial not to present any evidence. He made some brief, very brief cross-examination of some of the witnesses, but nothing else. Now, at this point, at the last hour before we were to make closing argument, this is an attempt to get information in through the back door. And that backdoor process is going to be violative of my client's right to a fair opportunity to present his argument here. Because, Judge, if you allow Summer Shiflett in, I am going to be compelled to ask the court to continue ruling on this motion so that I can bring Mr. Smith back, put him back under oath, and offer rebuttal testimony for Mr. Smith to counter whatever Ms. Shiflett says or to concur with whatever Ms. Shiflett says. And I don't know what Ms. Shiflett says. I haven't heard from Mr. Smith whether Ms. Shiflett even has legal counsel. And if she has legal counsel, Judge, Mr. Smith needs to be present for that examination. And quite honestly, if they're going to be allowed to reopen something that this court closed, and they have cited no rule that allows them to reopen this, other than a professional conduct rule, which is totally inapplicable, they shouldn't be allowed to do this. Because if that's where they're going, rebuttal is going to include Mr. Smith again. It's going to include an examination by Dr. Davidson again. It's going to include an examination by Dr. Newton, and potentially one other witness that I'm going to call to address that. And quite honestly, this is just an opportunity to somehow backdoor some information in that doesn't go to the root of what the problem is. I think counsel for Mr. Wood misunderstands. The due process argument is only a very small portion of this argument. The reality of the argument is this, Judge. Mr. Wood engaged in conduct that defense counsels both found objectionable. It's not the impact on the witness that conduct that's the question here. The question is whether his conduct itself was egregious enough to have him removed as the prosecutor. It has nothing to do on the influence other than the small portion of due process that'll be addressed later in another motion. The question here is whether Mr. Wood's conduct was egregious enough that it warrants some sort of action by this court. And the example is, Judge, this. Obviously, all of counsel agree that case law on this is very limited and there's not a lot of precedent. But if a prosecutor were to talk to a witness outside of the courtroom and say, oh, by the way, before that witness took the stand, by the way, the defense attorney is a liar and all of these other things that have been alleged, well, not alleged, they're on the tape. And then that witness was permitted to take the stand. It would not be the impact on the witness that the court would be evaluating. It would be, what did you say to that witness that potentially influenced you? So that's what the consideration here, Judge, is not what the impact was on Ms. Shiflett. It's what conduct was engaged in that caused the problem that he should not have gone down that road in terms of the way Mr. Wood presented himself and acted for 20 minutes on a tape. So quite honestly, Ms. Shiflett's testimony is really irrelevant to this. It's the conduct of Mr. Wood that's in question here. And I vehemently am opposed to allowing Ms. Shiflett to testify at this point.
All right, thank you for the response, Mr. Pryor. Mr. Evans, rebuttal argument.
Your Honor, just one clarification. If you look on paragraph 10, let me just be clear what the state's wanting to do. So moves this court to allow contact with Ms. Shiflett. The court knows bar counsel was called with this. So the prosecutor's office contact with Ms. Shiflett and or allow her to testify in the court. So Rule 4.2, if you look at the very bottom, that is the state asking to contact her. And so how do we do that when they have been represented by an attorney? You need to get permission from the lawyer, if she still has one, or authorized to do so by the court. So that was done with bar counsel, and that's what the motion is. So it's the state to communicate with her as well as her to communicate with the court. Thank you.
All right, thank you, Mr. Evans.
Your Honor, may I respond to that rebuttal? Because there were some new arguments made there.
Keep it brief, Mr. Means.
I will, Your Honor. When we go through the affidavits of Mindy Gee, given the rulings of this court, the only thing that's admitted that's not stricken as hearsay are paragraphs 1, 2, and 3 of both of the affidavits. Paragraph 4 on the original affidavit would be limited to, on January 7th, 2021, at approximately 2:53, I took a phone call from a female individual. And then the portion after that would be hearsay. Then it says, I stated that he was not available and asked if I could take a message. The rest would be hearsay. Concluding on paragraph 4, the only portion that's not hearsay then says, and I told her I would relay the message. The phone call then ended. The same thing applies to the supplemental affidavit. 1, 2, and 3 should be admitted pursuant to this court ruling. And paragraph 4 is limited to, on January 8, 2021, at approximately 9:30, I answered a phone call from a female individual who, and then the rest is stricken as hearsay. So we don't have affidavits supporting this motion as a result of the court's ruling. There's also additional hearsay from alleged statements of Ms. Shiflett in their motion. In addition, if we look at Rule 4.2, and again, this is just brought up this morning, if you look at comment or paragraph number 6, what they're requesting is beyond what the rule cites. Again, there's no grounds to allow this cited in this rule. If they're asking for permission to speak with Summer Shiflett, I don't think any of us have an objection. The problem is they're attempting to extend the rule or imply what's not in there of give us permission to speak with her and have her testify. That's not part of the rule, Your Honor.
All right, thank you, Mr. Means.
Thank you.
Well, counsel, I've considered this motion in terms of where we are procedurally. Of course, we had a very lengthy hearing 2 days ago on the 6th. We took evidence and testimony during that hearing. We then concluded with the hearing and closed the submission of evidence. This is essentially a request to reopen the submission of evidence, and the request specifically to allow, as the motion reads, for the court to contact and hear the testimony of Summer Shiflett, and then in paragraph 10 to allow her to testify before this court. And that would be based on, again, Ms. Shiflett's request. It says, as Mr. Means pointed out, with the striking of the portions of the affidavits of Mindy Gee that contain hearsay, then the grounds for the motion don't qualify without those statements. And in addition, the motion is brought pursuant to the Idaho Rule of Professional Conduct 4.2, and the court's not aware of the Idaho Rules of Professional Conduct being a proper basis for bringing a motion. At this time, for purposes of the hearing today and our closing arguments, I am going to deny the motion to allow the testimony of Summer Shiflett. So the evidence submission is still closed, although we do have the arguments that have been submitted, which will be considered. So that'll be the court's ruling on the motion. This time then we'll proceed with our closing arguments. Counsel, as I mentioned, we went through and reserved today for these closings. I'd like to take those up at this time now, and I'll just let you know I'm intending to hear your oral arguments. I'm going to take a recess at some point and further review your submitted briefing in addition, but Mr. Pryor, be my intention to have you begin with your closing, then have Mr. Means, and then I'll have the state respond in their closing as well, and then see if there's any rebuttal arguments. So, Mr. Pryor, are you ready to proceed with your closing argument?
I am, Your Honor, if I may.
Go ahead.
Judge, I think there's a misunderstanding by counsel for Mr. Wood. The basis for disqualifying a prosecutor is conduct. It's not the impact that it has on the witness, but rather its conduct. What I spoke about, Judge, was this in the example I gave just a short time ago. The example is this, is that if you have a witness who's about to take the stand in a jury trial, and either party for that witness approaches them and makes disparaging remarks about defense counsel, makes disparaging remarks about the defendant, and I can't see in any situation where suggesting that someone's a wimpy person or looked like he was about to pee his pants are not disparaging remarks. I can't see where calling Mr. Means incompetent is not a disparaging remark to a material witness. And whether Ms. Shiflett testifies or not for the prosecution is irrelevant. Because if I choose to call her, she becomes relevant. If Mr. Means chooses to call her, she becomes relevant and material. And she's the sister of one of the defendants in this case, who was told, oh, by the way, you know, she won't talk to us, but this is what I'm going to do, and I'm going to charge her with murder. And it would sure be nice when she has competent counsel. Maybe we can get this thing closed up. I can't think of any more direct way that he's trying to circumvent Mr. Means' authority as counsel for Ms. Vallow. It's egregious. It is incredibly egregious. Now, Judge, the Idaho Rules of Professional Conduct have adopted the ABA model rules. And the ABA model rules, and Judge, that says it right in the preamble to the Idaho Rules of Professional Conduct. We have adopted the ABA rules from 1969. And under the ABA rules, ethical considerations, Rule 9.4, because the very essence of our legal system is to provide procedures by which matters can be presented in an impartial manner so that they may be decided solely upon the merits. Any statement or suggestion by a lawyer that he can or attempt to circumvent those procedures is detrimental to the legal system and tends to undermine the public confidence. Now, that's from the ABA rules, Judge, which have been, for all practical purposes, adopted in our Idaho Rules of Professional Conduct.
Mr. Pryor, I do want to make a correction there, because the Idaho Rules of Professional Conduct are, as it states in the preamble, largely based on the ABA model rules with some Idaho variations.
That is correct.
I would ask that if I'm following along here, if you're citing to any specific rule of professional conduct, please cite to the Idaho rule, because they are largely the same, but if there's a difference, we need to rely on the Idaho precedent. So,
and I understand that, Judge, and what I'm trying to do is I'm trying to say, in the spirit of adopting the Idaho Rules of Professional Conduct, they considered the ABA rules. And it still goes to the same essence, Judge, which is this. Our Idaho Rules of Professional Conduct require that we do everything we can as lawyers to engage in an impartial system that does not allow undue influence from any party or their attorneys to jeopardize the opportunity for a defendant to have a fair and impartial trial. I cannot think of any situation that is more egregious than a prosecuting attorney who would go in and interview a witness and for 20 minutes not interview the witness, but rather offer a monologue of what his theory is in the case, disparage counsel, disparage the defendant, and manipulate. Now, I want to point out that the prosecutor in this case presented no evidence in rebuttal to counter Dr. Davidson, to counter Dr. Newton, and to counter Attorney Garrett Smith. They offered nothing. And to suggest this high scrutiny by Mr. Wood's attorney is completely inaccurate. The question is whether or not an attorney and a prosecutor who's required to live by a higher set of rules has engaged in conduct that jeopardizes Mr. Daybell and Ms. Vallow's right to a fair trial. Now, The purpose of Dr. Davidson, Judge, is this. I did not want to, and I can't speak for Mr. Means, but I didn't want to subject Summer Shiflett to all of these people out there watching this and put her on the spot. Dr. Davidson got on there and he testified that it's, without credulity, that there was not influence here. He's suggesting, listen, there's no way there wasn't influence here. And he specifically put a report that has been admitted and detailed every single line of where Mr. Means engaged in completely inappropriate conduct. Now, I read the brief from opposing counsel and they said, well, this isn't what was going on, but Mr. Wood's affidavit in the original objection to this, Mr. Wood specifically said in his statement, I did not coach, influence, or intimidate any of these witnesses. Well, I beg to differ, Judge. Dr. Davidson, in no uncertain terms, stated implicitly that these statements clearly were influential in a attempt to influence Ms. Shiflett, without a doubt. Dr. Newton, when we talked about the process here and what was transpired, what did he say at the conclusion of the hearing? Well, the reason we don't have these sort of things is because it's unusual for these matters to occur other than in front of a jury. But when they occur from a witness, it's a rare situation. And you want to believe a prosecuting attorney. You want to believe someone who is supposed to be righteous and uphold justice and do it the proper way. And the tendency with courts is to say, listen, unless you have some proof that the prosecutor has engaged in some conduct that is detrimental to the administration of justice, I think it's appropriate because his job generally is to uphold justice. But what did Dr. Newton, the expert on case law, the expert on authority, what did he say that was compelling? He said, he, meaning Mr. Wood, got caught. Now, getting caught is not the term you use unless either you're fishing or you're lying or you're cheating. And Mr. Woods is cheating, Mr. Wood is lying, and Mr. Wood is doing nothing but trying to influence, coach, intimidate a witness before that witness has had a chance to get in front of a trial. My concern is this, Judge. I don't have any other recordings other than Zuluma Pastenes. And I'll be going through that, and we may be revisiting some issues once I've had a chance to go through that in the final interview with Ms. Pastenes. But I don't have any other tape recordings. But what I do have is an interesting thing that occurred. And I know this court wasn't part and parcel of the preliminary hearing back in August of this year. But I had an opportunity during that preliminary hearing to talk with Ms. Gibbs while she was on the stand. And I was questioning her about what she knew, what the prosecutor had said to her. And after I asked her what the prosecutor had said to her, Judge, she immediately turned on the camera and looked directly in Mr. Means's eyes. And I said right after that, why were you looking at Mr. Means?
Your Honor, I'm going to object for hearsay.
This is argument, Judge. This is argument. This isn't the presentation of evidence.
I understand, but you're still referencing a specific comment someone made out of in a separate proceeding. I think that's hearsay.
Okay. Well, Judge, my concern is this, is that having to bring up the subject of whether Ms. Gibbs was looking at Mr. Wood when I said that, and the fact that I brought it up, and the fact is, Judge, I observed Ms. Gibbs look in the eyes of Mr. Wood when I'm questioning about what sort of conversations they had. That causes me great concern. And everybody in the world can look at it on YouTube and see that there was concern. So what assurance is the court going to be able to give me that these meet and greets that Mr. Wood has engaged in, these 20-minute monologues, have not occurred with every other witness in this case? Because if the court cannot give me assurance, you're going to require me to go to every witness with an investigator, interview them, and question them in detail about what Mr. Wood has talked to them about and whether this meet and greet tactic that is completely unprofessional, that is completely unethical, that is completely wrong, was conducted on other witnesses in this case. And if that can't be questioned to a certainty and assured that there hasn't been influence with other witnesses, how am I going to be sure that there's going to be a fair trial for Mr. Daybell? Because you can't. And there is only one thing this court can do. We need to remove Mr. Wood, and then there'll be additional requests regarding the witnesses further down the line in terms to how we try to cure this atrocity. Judge, there are a number of problems that I have in terms of the Idaho Rules of Professional Conduct. And in terms of the Idaho Rules of Professional Conduct, Judge, we do have Rule 4.2. And Judge, it is misconduct if you violate any of the Idaho Rules of Professional Conduct. And at this point, under 4.2, you are not allowed to encourage or in any way try to contact someone who has legal counsel. I cannot see how Mr. Wood's statements leading Summer Shiflett through this process of, oh, it's going to be murder charges, and it would sure be nice if we could communicate with Miss Vallow about this. And as Dr. Davidson implied, it seemed to be, and Dr. Newton implied, it seemed to be a back way for Mr. Wood to try to get Ms. Vallow to speak. Now that's clearly a violation if you're trying, even secretly or indirectly, to try to communicate with a witness or with a defendant who has legal counsel. That is a big problem. In addition, he violated the preamble. He is not doing this. There is no way anyone can suggest that his comments did not influence or attempt to influence a witness in a case. That's not justice. 3.8, the prosecutor's obligations. He violated his obligation as a prosecutor to try to present an impartial hearing, and his heightened obligation to do everything that he could to be fair and afford the opportunity for a defendant to have a fair trial is a violation, another violation. And Judge, I can spend hours going through and point out a number of these. Now, obviously, I've been verbose, and I've been verbose in the past, and the court has been very patient with me. But if the court looks at the transcript of the proceedings by Dr. Davidson, if the court reviews Dr. Davidson's report, he makes an emphatic representation that this was influence. Now, Dr. Newton was not going to circumvent the court's authority to make that decision. Dr. Newton was not going to override the court's power and say, oh yeah, this is prosecutorial misconduct. He said that it was up to the court to make that decision. It's up to the court to decide whether this is enough for there to be a disqualification of Mr. Wood. But what he did say, which was interesting to me, Judge, is this. He said, Mr. Wood's behavior was a learning moment, and he meant for his future students at law school. It is a learning moment on what not to do. On what not to do. That would suggest to me that it's a clear ethics violation. What else would suggest to me from Dr. Newton that it was a clear ethics violation is that he would get caught and that he got caught. And again, as I stated before, when someone says you got caught, either you're fishing or you're breaking the law or you're a cheater or you're a liar. I'll pick which adjective because I don't think Mr. Wood was fishing. Now, Garrett Smith in one of his closing arguments at the end, or his testimony, stated, I can't see any possibility other than that it was influencing or attempting to influence Summer Shiflett, and there is no reason for why Mr. Wood did this. Judge, the totality of the circumstances are this. We have one of the biggest trials in the state of Idaho, and people are watching this with attention that I can't even fathom. We are all under the gun and we are all being watched very carefully. And any first-year attorney who's going through law school is entrusted by ethics and taught about ethics, that these are the things you do not do. And Mr. Wood has been practicing for a while. He has told me before that I did plenty of defense work. I'm a prosecutor now. And Judge, for the record, he also told me on 2 separate occasions
Your Honor, objection for hearsay.
Sustained.
Judge, I can't think of a reason why Mr. Wood would need to go out and interview Summer Shiflett. Mr. Wood took it upon himself to go out to Arizona to interview a witness. He knew before he was leaving that he was going to engage in this meet and greet and do this. Because if he didn't know that he was doing it, then he doesn't understand the rules of ethics. He can't say, oh, I didn't know what I was doing. He knew darn well what he was doing. And the only problem and the only complaint is this, Judge. He got caught. In the infamous words of Dr. Newton, he got caught. And to suggest by distracting, saying, well, Ms. Shiflett will say something else. Or, Judge, the impact on the witness. That's not the standard. It's the conduct. The standard is, was your conduct so bad that it had an impact on the trial in this case? I can't think of a more egregious situation other than a prosecuting attorney in one of the most high-profile cases in the state of Idaho, and I could argue, Judge, in the United States. I don't know how many people are watching me right now, or watching us right now, but I would imagine it's significant. And this prosecutor, with full knowledge and at the expense of Fremont County, chose to fly out to interview a witness and suggesting that it was going to be a meet and greet, and then spends 20 minutes of a narrative doing everything he can to influence this witness to testify a certain way. And it's not whether the witness was influenced. It's the fact that he did it. And who else did he do it to? What other witnesses in this case did he do? Because we'll never know. We will never know the extent of what this prosecutor has committed in this particular case. And I can't think of any better reason to disqualify him than the fact that we don't know what else he has done. And quite honestly, Judge, anything he says about what he has or has not done, I have very little faith in anything Mr. Wood will say. And at this point, I will defer to counsel.
All right, thank you, Mr. Pryor. Mr. Means, your final argument.
Thank you, Your Honor, and I obviously concur with Mr. Pryor on his points made. Does the court want me to go ahead and attempt to argue some of the points made by the state's brief that was filed this morning as well in the closing, or do you want to save that for rebuttal, Your Honor?
I'll leave that up to you, Mr. Means. If you want to address the points in their brief, at some point we'll get to that. You can determine if you want to do that in rebuttal. I'll allow rebuttal, or if you'd like to do that now in your closing, you can.
Thank you. I just, in trying to organize my thoughts and present it in a more efficient manner, I'll try to go through it rather quickly. I filed this morning a post-motion hearing brief in support of the motion to disqualify. Overall, the motion doesn't introduce anything that wasn't presented at the trial in this matter, but to assist the court in the finding that Mr. Wood should be disqualified from this action. It's a summary of the pleadings and the filings which have been filed in here with some dates, and then some reference and summaries to each of the three witnesses that were that had an opportunity to testify before this court. I'll go ahead and I'm going to object to any and all potential arguments by the prosecution in this case that were not expressly brought up at the hearing, either through lack of evidence or lack of questioning or limited to their cross-examination questions. I think anything else would be in violation of the spirit of the law of closing the evidence in this matter. And we can take that up, obviously, as we go along. In summary, Your Honor, when you look at the recording and you read the transcript, I think the initial impression is red flags are raised, eyebrows are raised. When you listen to it again, I think it becomes quite a bit more disgusting when you hear the tone and the phrases and the speed of the language and the words used. When we look at here in a summary, you have Mr. Wood admitting on this recording that he was in Hawaii at the time that Mrs. Daybell, was arrested. He was in Arizona at the time that the statements from these witnesses were taken. I still have yet to try to figure out why he's present at any of this. as I listen to this recording over and over, I think the biggest question is why? Why are we here? Now we have spent substantial amount of time with the court, tens of thousands of dollars, many hours in the court's time and the attorney's time, and addressing an issue that should have never been an issue to begin with. And in response, the only objection or evidence that the state has put forward is their initial objection and an affidavit of Rob Wood. And then we have very limited cross-examination questions at the actual hearing. When we look at, in addition, when this tape was discovered, I served on December 17th, and this is part of the record that is readily available for everyone, a specific set of discovery requests to the prosecutor's office asking what contact, in summary, what contact this prosecutor's had with all of these witnesses, and I listed some specific witnesses. Discovery responses were due to that specific request by January 2nd. That's the 14-day limitation according to the rule, Idaho Criminal Rule 16. It's expressly set out there.
I'm going to object. I just don't remember any discovery things being brought up in the hearing.
Well,
Your Honor,
there's a separate issue out there, Mr. Means. I think, correct me if I'm wrong, did you file a motion to compel?
I did file because it's now time to file that motion to compel. But why this is, sorry, Your Honor, I don't mean to.
I'm just going to say that's not being heard today. If there's a need for hearing a motion to compel and you still don't have responses and think that needs a hearing, sure, we'll get that scheduled and take that up at another time. So go ahead and move on.
Your Honor, and I understand that my intent for arguing this is we were limited in presenting the evidence before the court of potential other violations and inappropriate contact with the witness, and we attempted through the proper means of discovery to get this evidence from the prosecution, and they failed to respond. There was no request for an extension of time. There was no denial. There was no objection to the discovery. They failed to respond.
Your Honor, I'm just going to object to that again for the same reason.
All right, I'll sustain that objection. We're not doing the motion to compel right now.
Sure. Thank you, Your Honor. When we do a summary of why Mr. Wood should be disqualified here, we have four main exhibits for the court to consider. First one is the transcript of the recording, the actual recording of the monologue, and then the expert reports 3 and 4 of Dr. Davison and Dr. Newton. There were 3 witnesses that testified. Prosecution had ample opportunity to call contrary witnesses or cross-examination, extended cross-examination, and they chose not to. We had attorney Garrett Smith of 27 years. We had Dr. James Davison and Dr. Newton. All of these witnesses, or excuse me, let me go through Mr. Garrett or Mr. Smith first. He testified right up front that he had an opportunity to listen to the recording. In fact, I believe the recording was played at the hearing with him on the Zoom stand, I think we'd say, and he testified that it was an accurate copy, an accurate depiction of the conversation between Mr. Wood and Ms. Shiflett, that it was unaltered and it was a true copy. He then goes on and states that the affidavit filed by Mr. Wood in this case is false according to his opinion and recollection of events, specifically affidavit paragraphs 4, 6, and 7. He also has the opinion that the only intent of, the opinion that the only reason to really engage in this type of behavior was to unnecessarily and unduly influence Mrs. Shiflett. That Mr. Wood, and I think this adds to the fact that Mr. Wood knew Shiflett was a member of the Church of Jesus Christ of Latter-day Saints, or LDS, and that he knew she has strong convictions and feelings regarding that religion. He also knew that she has a strong emotional connection with her sister, Lori.
Your Honor, we object. These are facts, not in evidence. We have no idea what Mr. Wood knew or didn't know.
Your Honor, the objection should have come, if that was going to be, at the hearing. This is summarizing his testimony for the court that was not objected at the time that this was presented.
And I'll overrule the objection because it is some summation of this testimony. So you may proceed, Mr. Means.
Thank you, Your Honor. No, it's important to context this entire conversation that Mr. Wood is having with Ms. Shiflett, having this knowledge here. I think it's an important factor for the court to consider when it's analyzing coercion and manipulation and intimidation and these type of things that come up at a later time. In Mr. Smith's words, he said his 27 years of practice, he's never seen a prosecutor engaged in this type of behavior. That it appeared to be targeted at coaching and influencing the witness, and it appeared to come across as a win at all costs type behavior. This is obviously an issue for the court to consider. Dr. Davison again testifies in reviewing the recording transcript and looking at the affidavit of Mr. Wood, that the affidavit again filed by Mr. Wood, paragraph 4 and paragraph 7 are false according to his expert opinion. He also testified that Mrs. Shiflett is a vulnerable witness, and the knowledge that Garrett Smith provided to the court of Mr. Wood is important in determining that, yes, there should have been gloves on the hand when handling Ms. Shiflett in this situation. He goes on to say, Dr. Davison, that the monologue is troubling, that appears to be no apparent effect to seek impartial testimony from the witness, numerous efforts to influence and exploit and shape the witness narrative. He also goes on to say that the prosecution pours his theory of the case into this witness prior to the testimony of the witness, that there are derogatory remarks regarding defendant Chad Daybell and myself. And when you actually look at the recording, he's also in certain ways derogatory toward Mr. Pryor and my client when you look at his opinions that are being expressed. He also attempts to bring in LDS doctrine as an authoritative speaker on behalf of that doctrine. He also attempts to assimilate or build a commonality with Mrs. Shiflett based on mutual beliefs in the LDS Church, which obviously is completely inappropriate. He also goes on to say that Mr. Wood engaged in coaching, testifying, and had an effort to unduly influence the witness. He attempted to shut down the witness. He attempted to control the narrative, and there's little interest in what the witness's information that will be provided. He's attempting to increase his credibility through derogatory comments and mutual association with religious beliefs. He attempts to, there's a prima facie influence of the witness. He halted any disagreement by Ms. Shiflett. And again, summary, he engaged in derogatory remarks as if we are in third grade in an attempt to, according to Dr. Davison, affect this witness. He summarizes by saying that there are minimal attempts from the state here to actually get the witness statement rather than to say his own. Now, when we look at the prosecution had an opportunity to present cross-examination and additional witnesses, there was minimal at best. I think they went into some questioning regarding page 5 of the transcript, lines 8 through 11, I believe, and that was the only substantive questioning there. And Dr. Davison handled that with his, my opinion remains the same. The words are there. His report remains uncontested. Dr. Newton, professor, University of Law, published author, also came in and said, and I admire his opinion for not trying to come across as to tell the court what to do, but to give you the information and allow the court to make the decision. He says he was, even though retained by my office, that his testimony was given freely, voluntarily, and without any coercion by any party. His summary, and I think this is important, he identifies and properly identifies Mr. Wood as acting in a quasi-judicial figure, a higher standard of law. Not only do we have the Idaho rules of professional conduct that apply to all of us, but there's a higher standard of law for Mr. Wood. If I could put it in summary, the ledge for a typical attorney to fall off is a little further away than it is for the prosecutor. He goes on to say that Mr. Wood presents his case to the witness as if conclusive and sound. He goes on to provide information that is not readily known. He said Mr. Wood is providing unknown information to the witness could be found to have unfairly and improperly influenced the witness to alter her testimony. Now, again, this is all caged or described in an attempt to allow the court to come to the conclusion. He also goes on to incentivize, according to Dr. Newton, the testimony of Summer to coincide with the state. This is, as Dr. Newton cites, potentially unethical. It's also potentially criminal. He goes on to say that the prosecution, without question, poured his versions of facts into this witnesses. He calls this horse shedding, wood shedding, and coaching. And he also goes on the site and says this is widely condemned. This is not getting to the line. This is a no-no. He then had, by Dr. Newton, put Shiflett in a compromised position. And just thinking of how this is going to affect ultimately this case, is mind-boggling at this point in time. He says his behavior bordered on intimidation, that he attempted to possibly circumvent the attorney-client privilege between myself and my client. He goes on to say that the use of religious beliefs, affiliation, and authority is an improper use. The derogatory remarks are improper, and that these remarks and his monologue serve the purpose of predisposing a witness against the defense. This not only violated the spirit, if not the letter of the law of the Idaho Rules of Professional Conduct and potentially the Idaho laws regarding witness tampering. He also goes on to say that there are coercive aspects. This is all of the things which are uncontroverted, unchallenged by the prosecution. I think the question before the court is, what standard do I review this? And it's my argument that this is a standard of abuse of discretion, that the court has to look at this issue and determine, have there been enough violations here, just in those cited by those experts, to justify removal, to ensure the integrity of this process. The Idaho rules, as the court has mentioned, asks us to cite specific rules. I've read these rules. I've read the comments. I see a plethora of issues here. We got a violation of the preamble. We got a violation of Rule 3.4 A, B, C, F. We got a violation of 3.5 A and D, Rule 3.7, Rule 3.8 A, D, F, G, 1, Rule 4.1, 4.2, 4.4, A1, Rule 8.2A, 8.4, A through E. These are major issues, Your Honor. And again, the question has to ask, why are we even here to begin with? These, in addition, this recording is going to have application to this entire process, Your Honor. And looking at their brief quickly, I have in my notes here at the beginning, it's a 13-page red herring. They assert contradictory positions. They imply that the prosecutor may have acted in a matter of error, but that's not enough to disqualify him. It cites various standards of law that they say apply to when it's at trial. But by the way, Judge, we're not at trial, but they attempt to apply that standard. They attempt to apply a standard of review on whether a conviction should be overturned. They cite things such as appearance of impropriety. I think that's a foregone conclusion that we have here. And then goes on to say, no, it's a standard of, well, is the person damaged? Is the testimony damaged? Is there harassment here? Is it an effect of the trial with unfairness? Again, citing cases that are relevant to a trial and saying that shouldn't apply, but by the way, it should apply, we should hold them to the standard, I don't think is a logical conclusion to come through. They selectively cite the preamble of Idaho Rules of Professional Conduct and leave out the portion paragraph 6 of lawyers should further the public's understanding of and confidence of the rule of law and justice system, because legal institutions in a constitutional democracy depend on the popular participation and support to maintain their authority. We have some other sites in the preamble which he also violates by derogatory comments of opposing counsel. I think if you go through, there's legal conclusions in their briefing that are not supported by the facts. They make statements such as there was no evidence presented of coercion or intimidation or these type of things. In fact, the one that really caught my eye just off of a few moments of reviewing this is they maintain that Mr. Wood did not tell this witness what to say. And one of the issues brought up with Dr. Davison on page 5 of the transcript, line 10, Mr. Wood says, "So what I want." There's just no way around that. There's just no way around that. He's telling this witness what he wants to hear. He's pouring his theory into this case of this witness. This is not a dead issue. There are other witnesses that have to be investigated now as a result of this. And so, Your Honor, I think it's well within the court's discretion, well within the court's authority in this case to disqualify Mr. Wood to protect the integrity of the process. I think when we look over the past 6 to 8 months and we take an opportunity to read the tea leaves, The riots and the objection and the protesting, demanding changes in the criminal justice system is the exact reason why we're here today. This is completely unnecessary. He had no reason to be in Hawaii, as if he had to help the Maui police or prosecutor office serve warrants and arrest this person. He's made himself a witness by testifying what he personally reviewed and saw and the statements made. We also have no reason for him to be in Arizona. He had investigators down there from local authorities, from the FBI there to question this person. In fact, it's evidence that he didn't need to be there when he walks out of the room, and by his own affidavit, the investigative process, the questioning of the witnesses was done by the investigators. By him leaving the room, he is showing that he had no business to be there. And then that goes to the idea that I think the court can conclude through a preponderance of this evidence presented, that his intent to be there was to manipulate the testimony of this witness. And that goes to violations of the rules, violation of the criminal rules. And this court, at the end of the day, has to determine what kind of precedent it wants to set with this type of actions. If this type of behavior, in my opinion, goes unwarranted, unchecked, unsanctioned, you are telling myself, Mr. Pryor, the prosecutor, and anybody else who wants to cite this case in the future, that you can engage in these tactics without repercussions. That is a dangerous precedent that I don't think any court or any witness or defendant would want to have. I would not feel comfortable engaging in this type of behavior. Justice should prevail. The only person here of these parties is a prosecutor, as a quasi-judicial officer, has a duty to ensure justice, and that was perverted at the least, Your Honor. Thank you.
All right, thank you for the closing. Mr. Means. Mr. Evans, would you like to present your closing now on behalf of this?
I would, Your Honor. Thank you. Your Honor, I'll note initially, counsel said our briefing is 13 pages of red herring. I noticed from counsel's briefing that there's not a single case offered in support of anything. There's no theory, there's no standard, there's nothing. They cite the Idaho professional rules of evidence that I'll get to in a minute, and they cite the Idaho criminal rules. Not a single case. The state's briefing, on the other hand, goes through an analysis of Supreme Court case, letter of law that the court has to follow. So with that, Your Honor, I want to start with the issues that are set out in their motion to disqualify. I think this is important. So there's 6. The first one, violation of the defendant's right to a fair trial. The second one, prosecutor violated the rules of professional conduct and the ABA rules. Number 3, witness tampering and intimidation. Number 4, the prosecutor is now a witness. Number 5, could be a future civil action. And number 6, there's Brady and Rule 16 problems. So I want to be clear, the grounds for the motion to disqualify are 6 things. And I want to lop off the low-hanging fruit. And I want to start first with number 2. So the prosecutor violated rules of professional conduct. The ABA. Your Honor will find on page 5 of our brief, Idaho law from our Idaho Supreme Court. In fact, Justice Moeller, a great Rexburg native, is the one that penned the decision in Kozman versus Dinius. That case very clearly states issues of sanctions of ethical conducts or violations of lawyers in this state is a decision for the Idaho State Bar, not the trial court. This is an Idaho Supreme Court case. The Idaho Supreme Court went on to say that we have designed a comprehensive scheme for submitting complaints and ethical violations, imposing sanctions where warranted, and for appealing those adverse decisions to the Idaho Supreme Court if needs be. Thus, I quote, the district court appropriately recognized that whether to issue sanctions for an ethical violation is a decision for the Idaho State Bar, close quote. Your Honor, we have a United States Supreme Court case that states in Strickland versus Washington regarding the ABA that those are just guides. They're only guidelines. They're not enforceable. Counsel has never shown one proof that we're under some obligation to follow the ABA guidelines. We can follow them if we want. There's no penalty if we do not. And so issue number 2, Your Honor, the prosecutor violated rules of professional conduct, which they've spent a lot of time on, is completely irrelevant. It's completely irrelevant, as well as the ABA rules. It couldn't be more clear, and I would challenge counsel to show me a Supreme Court case that says otherwise, because I've got 2. Your Honor, so that's issue number 2. Issue number 4, the prosecutor is now could be a witness in the case. I discussed this in page 7 of my brief. Again, I outlined the standard for the court. It's a compelling needs standard. The defense must show evidence that it's vital to a case, and you can't get this information anywhere else. So what do we have here? We have got a couple of exhibits with an audio recording, with a transcript, already a part of this court's evidence. And so why do we need Mr. Wood to testify to anything? Why do we need to have him called to do anything that we've got a recording of and we've got a transcript of? Again, it's a compelling needs standard. I outline, again, Idaho court cases that counsel does not. I outline these for the court that shows that he cannot be called as a witness. They have shown no compelling need. Again, it's their burden. They've got their 6 issues. They fail on the first 2 that I'm talking about. So that's issue number 2 and issue number 4, Your Honor. I'd like to turn to issue number 5. Mr. Wood needs to be disqualified because there could be a future civil action filed against counties. They provide no authority. They provide no evidence 2 days ago of what that is. They just claim that they need to be disqualified because of some future threat of a lawsuit. They're throwing things at the wall, praying that something sticks. The rule on that I cite in my brief, and we also have a ripeness doctrine problem with their methodology. It's not before the court. We can't disqualify somebody now based on whether or not a case is going to be filed in the future. I know that's black letter law. So again, their issue number 5 completely fails. Issue number 6, Brady and Rule 16. I'm not involved with this on the previous matters, as the court knows. It sounds like Mr. Mean was trying to bring up some issues of whether or not discovery. I don't know what that is. But as far as this hearing, as far as what's gone on and Mr. Wood's conduct to be disqualified, I haven't heard a single thing that would disqualify him because of Brady or Rule 16. You'll note I cite the law in the state of Idaho. I cite the cases that back that up. Everyone has a transcript and a tape of this matter. This is not an issue in this case. So, Your Honor, just a summary of those 6 issues, issue number 2, 4, 5, and 6, there is 0 issue at all with those being dismissed. They haven't met their burden, and it's their burden to meet, and they just haven't met any part of that. So what we're left with is the fair trial and then the witness tampering. No for the court, and by the defense's own witness, Professor Newton, prosecutors are supposed to talk with witnesses. Dr. Newton agrees with this. This happens all the time. Witnesses are different than jurors.
Your Honor, I have to object to the characterization that this happens all the time. I think he's implying that the manipulation of coercion happens all the time. I don't want to interrupt counsel, but that's a gross misrepresentation.
I'll overrule that objection. Go ahead, Mr.
Thank you. Thank you, Your Honor. Counsel doesn't like the words Mr. Wood used, or maybe the words that are placed in order that Mr. Wood used, but there's no coaching and there's no intimidation. I guess in my mind, I liken this to, and we don't know, with Summer Shiflett not being able to testify, we don't know what she knows or doesn't know. But I summarize this in an example for the court. So let's take a red light example. So if I'm a criminal prosecutor and there's a hit and run and it's an issue of whether the light was red or green. And I have a host of witnesses that say that light is red. And then I have one witness that says, no, I think that light was green. So I bring that witness in and I say, all right, witness, everything that I show on it, law enforcement, all the other witnesses say the light was red. and you're saying that it was green. Here's the other statements you ought to read. You can talk with the other witnesses about this.
Your Honor, if I may, I want to object to this proposed hypothetical. It wasn't included in the hearing. It's not included in his argument today. He's going outside of what he's presented to the court.
This is just argument, so I will overrule the objection. And
Your Honor, thank you. So back to my example, clearly prosecutors can't do this. We can't take a witness and say, everybody else has testified the light was red except for you. Here's some example. Here's the police reports. Here's all this information. Mr. Wood did not do this. Mr. Wood at no time suggested to a witness what to say. That's just not what he did. Again, page 6 of the brief, Your Honor, we cite case law, Supreme Court. So let's assume this court says, well, maybe it's close to the line. So what's the remedy? The remedy is cross-examination. It's interesting, the defense's own witness, Professor Newton, said, well, you don't have to disqualify Mr. Wood from the case. Maybe we should have a taint hearing. And I outlined this in my briefing, and Professor Newton also outlines that in his briefing, but maybe we need to have a taint hearing to see really what Ms. Shiflett knows and doesn't know, and what the influence on that is. So again, we do not believe that Prosecutor Wood violated those rules. I want to go to this standard, Your Honor. I think this is important. I think we would all agree it's been difficult to figure out a standard in this type of situation. I believe we've come close. And that standard is held in Weaver. I put the analysis in the documents. In fact, I'm starting on page 9. So we call this the Weaver factors, and I cite the case law to it, but the court in Weaver suggests a 4-part test. And I think that's important to look at on whether or not a prosecutor should be disqualified. Now, let me just summarize some of these, Your Honor, for the court. So we already know the burden to establish the grounds for disqualification rests on the defense. The goal of the court is to shape a remedy which assures fairness to the parties and integrity to the judicial process. When a motion comes from an opposing party, those motions have to be viewed with caution. So I appreciate counsel's argument that that's my argument. Counsel's wrong. I'm citing an Idaho Supreme Court case that is actually adopted in the Foster v. Trial case that adopts the Court of Appeals case of factors in Weaver. I outlined that starting on page 3 of the brief. Your Honor, I want to go through those 4 factors. So this is an Idaho Supreme Court case that adopted the Court of Appeals factors on whether or not an attorney needs to be disqualified. You'll note, Your Honor, it was in a civil standard case. It wasn't in a prosecutor's case, but I think the applicability still applies to lawyers. So let me just go through those 4 standards. Standard number 1, whether the motion is being made for the purpose of harassing the defendant. Obviously, the motion is being made by the defendant. Everybody's represented by the counsel. And so nobody is being harassed. No defendant is being harassed by Mr. Wood. The second factor to establish whether a prosecutor should be disqualified is whether the party bringing the motion will be damaged in some way if the motion is not granted. There's been a lot of argument, Your Honor, about the rules of ethics, about the Idaho criminal rules. There's not been one thing that I can remember hearing of how these defendants have been damaged in any way by Mr. Wood or Ms. Shiflett, frankly.
Mr. Evans, I want to back up a little bit to a comment you made talking about these Weaver factors.
Yes.
Did you indicate that the Weaver factors come from a civil case?
So this is, it is a civil case. In fact, you have that cite, Your Honor.
I think it's in the brief.
Yes, if you look at page 3. So what I've done in the briefing, cited the American Bar Association. Again, it's not authoritative, but the removal specifically of a prosecutor is cited there. I've cited matters as close as I can get as far as disqualifying a prosecutor because of conflict of interest. Then I also have the Weaver factors that I think it's a disqualification of a lawyer, Your Honor.
I understand. The Weaver factors, I guess, getting back to this first factor you just went through pretty quickly, was question whether the motion is being made for the purpose of harassing the defendant.
Right.
And if this comes out of a civil case, then would that not just be better to say the opposing party?
That's correct, Your Honor.
The answer is the motion's being made by the defendant, so of course that wouldn't apply, but if you looked at this in a context of this case, and we're looking at the opposing party, isn't that more accurate to state that it would be to harass the opposing party, not necessarily defendant as defined a criminal defendant, whereas in a civil case, a defendant could just be the other party?
I agree with that, Your Honor.
Okay, thank you.
Your Honor, so the second factor set forth by Weaver, and again, this is as close as I'm going to be able to get the court, and I've spent quite a bit of time over the last couple of days looking at this. But the second factor that I've talked with before was the party bringing the motion will be damaged by some way if the motion is not granted. I think I've reviewed that. I provided the case law on that portion for the court. A couple of other comments from me regarding that. There's no evidence from Ms. Shiflett that she was intimidated, threatened, or coerced. There's no evidence of that. She was represented by counsel. Her attorney never objected to anything that Mr. Wood said. And the defendants, again, have shown no damage to their client in any way if Mr. Wood stays on the case. So I'll move to the third factor that establishes disqualifications of lawyers in the state of Idaho. And I want to spend some time with this, Your Honor. So whether there are any alternative solutions or is the proposed solution the least damaging possible under the circumstances. And I want to use the defendant's expert witness of Dr. Newton because the court will recall, I spent quite a bit of time asking him the questions on this. And the question is, okay, what is the remedy? And so Professor Newton discussed some of those. And we already talked a little bit about the pre-trial tank hearing is what he called it. That is set forth in his briefing, page 17 and 18, paragraph 62 and 63. And what I understand that to be is the court could determine, is she going to be called as a witness? And what, if anything, is going to be false or inaccurate testimony in the case? So other potential alternatives is not allowing Ms. Shiflett to talk in trial or limiting that communication. But in the case, if this court finds any questionable conduct, one of the factors the court has to consider is, okay, what is the solution that's going to be least damaging in the situation? I note, and the court notes, there's not a single one of the defendant's experts, all were asked if they know of a single case in a situation like this where a prosecutor was disqualified by a court. I don't know that. The defense experts had no idea. I mean, there's not a single case that leads that to believe. So I assume that perhaps in those type of situations, courts are finding alternate solutions short of disqualification. So again, the third factor of Weaver, also adopted by the Idaho Supreme Court to establish the disqualification of a lawyer. The last factor, Your Honor, whether the possibility of public suspicion will outweigh any benefits that might accrue to continued representation. Again, Your Honor, the burden is upon the defense. They claim quite a bit of information of, well, we didn't call it as well. It's their burden. It's their burden throughout. The Idaho Supreme Court has said that very directly. So their burden is upon them to show any public suspension or suspicion. None has been offered in this case. Ms. Shiflett is not Mr. Daybell. She is not Ms. Vallow. She's a potential witness in the case. And there's no evidence to present that Mr. Wood directed her to say anything other than tell the truth. So, Your Honor, based on those, and again, we're trying to provide the court some information of what to go through, but every single one of those 6 factors The state's briefing identifies the legal standard and the cases and the analysis for the court to consider. We would encourage the court to look at that prior to making its decision. I'm sure we probably found a lot of the same things. Let me just summarize with this, Your Honor. These motions are made by someone other than a former or current client, which heightens the scrutiny, justifiably so. Motion to disqualify in the state of Idaho are disfavored. They must be viewed with caution. The burden is upon the defense. Our argument is the Weaver factors. And again, I outlined some more that are the criminal factors. I outlined the ADA rules. Our assertion is Mr. Wood did not violate those factors. And even if he came close with those factors, this court has the ability to structure a remedy, just like the defense's expert says. You don't need to disqualify Mr. Wood. There's a remedy for this. And the court's fully within its capable powers to be able to do that. All the defendants are represented by attorney. Their rights are all protected in this. And again, the remedy is not to disqualify a prosecutor. We have a trial in 7 months, Your Honor. I cite the Supreme Court cases on the dissipation of things that occur now versus trial. I think that's important for the court to consider, is if there's a taint, even if there is a taint now or a taint on October 1st of 2020, where is that going to be in 7 months? We have court cases, not summations, not guesses. We have court cases. They outline to the court what those are. We cross-examine the witness if they've been coerced, if they've been doing again, courts have said the appropriate remedy for this is to cross-examine, or there's alternatives, exclude the witnesses, those types of things. So, Your Honor, based on this, based on the law in the state of Idaho, based on the law in the Supreme Court of the United States, and what we have presented to you, there is not a way to disqualify the prosecutor, Mr. Wood, from this case. Thank you.
All right, thank you, Mr. Evans. Counsel, I'm going to allow for rebuttal argument. Before I do that, I'd like to take a brief recess to allow mostly for the court reporter to catch her breath here. And so I'll let the rebuttal arguments be made after that. I've got 2:55, so let's come back on in 15 minutes at 3:10, if that works for everyone.
That works for me, Your Honor.
All right, we'll take that 15-minute recess. Thank you.
Thank you.
Oh my goodness. All right, first of all, I apologize for some of my comments in chat. I'm being very reactive, which I don't normally do, because I'm just so angry. I am so angry at this nonsense. However, calming down a little bit and looking at this objectively and from a calm, logical, legal point of view. Okay. All right. So the other day we were all sitting here like, why aren't they calling Summer? Why don't they call Summer? Who are these other crazy people? Why don't they just call Summer? Now, a good point that was raised in chat. Perhaps the state was not allowed to reach out to Summer because Summer's lawyer was a witness. That does make a complication. Okay. Also, you know, when we started the live and someone told me, oh, look, Summer's on the witness list. Like, wait, what? I had no idea. I'm like, what are you talking about? I didn't even check the docket. I never would have assumed they would have added witnesses and things this morning before the hearing. Right? I understand that you can't always do that. All right. And the defense probably had a valid objection to that. Okay. It stinks and it makes me very, very angry. But what it appears from everything we've heard is that Summer herself reached out and said, hey, I want to address the court. Okay, so that's a little different. It's quite possible Summer watched the stream of this hearing the other day and was like, what? You said what? You know, and got upset and wanted to address the court. That's quite possible. So it's understandable, even though I really dislike it, like Lori Hella said, why the judge denied that motion. Okay, fine. We don't have to like it, but that is the law. So, okay. Someone asked, what is a rebuttal? Right now, we've heard the closing statements from John Pryor, then Mark Means. Then it was the state's turn. They presented their closing arguments, but the defense has a chance to rebut what the state just said. So they'll be doing that after this break. So, yeah. As told by Thielen, that's a good point. Summer was probably, I mean, this is all speculation, but I can imagine Summer watching this hearing, watching Garrett Smith testifying and being like, oh, no, you didn't. And firing him and calling Rob Wood saying, I want to address the court. This is crazy. We don't know that happened. Okay, that's just speculation. But it appears something similar to that happened. We'll probably never get to hear from Summer about this. Yes, I would love to be like, Summer, come tell me. Come on the live and tell us what you were going to say. We can't do that. We can't. That could impact the case. That could cause trouble. I will not do something like that as much as I want to. Okay. I want to call Summer to the live stream as bad as Rob Wood wants to get Summer on the stand. So I get it. Okay. But it stinks. It does stink. All right. What do I think of Evans now after hearing their closing? I have to say, I was not impressed with his opening argument that the rules of professional conduct don't apply in this situation. I'm like, whoa, that's kind of saying, well, yeah, maybe he did those things, but it doesn't matter because it doesn't apply here. That's not a really strong defense in my mind, really. It may be a legal thing, but that wasn't a winning argument in my mind and in my heart. He did talk about, there was one thing that he said that I thought was really good. I don't remember what it was now. I have to scroll up and see where I said it in chat. I'm not thinking that Evans's defense was as strong as I would wanted. He did go through the 6 items that we talked about from the motion earlier. Certainly the Brady violation, I don't see that at all. I really don't. The violations of professional conduct, all right, maybe they don't legally apply, but that's not the best argument you can really have. He didn't really push the fact that this was an informal meet and greet, not an interrogation or an interview, which is weird because to me, that's a really big deal. Maybe legally it's not that big of a deal, but to me, this seems like a huge deal. Right? This was not a formal interview. This was not a deposition. Summer was not under oath. It wasn't like that. They were just chit-chatting. Now, Mark Means, and man, I hate saying this, I really do, but Mark Means had some pretty good points, I thought. I don't like the fact that I thought he had some decent points, but I think he did. However, to me, the differentiation still comes in the fact that this was a private meet and greet. That's all. If this had been an interview or a deposition, then yeah, I could totally see what Mark Means was saying. I really could. But these are just 2 people chatting. This is a prosecutor and a family member of the deceased having a conversation that was sought out by that family member. And the questions that were asked were from that family member. I think Rob Wood asked, 1 question or something? It's going to come down to that, I think. It's going to come down to the nature of their conversation, whether or not Rob Wood violated these rules and if they apply to the situation. So, yeah, I was a little surprised by Mark Means today. We make fun of him a lot. We call him Skippy. We call him a stagecoach bandit. But today he was on point. And we have to give him that. He was on point today. He spoke succinctly. I mean, he got his points across. He spoke rather eloquently. He had everything lined up. He was very well prepared for his statement today, far more so than John Pryor. John Pryor just seemed to be blustering and bloviating and angry, and he just came off bullish. All right, Mark Means came off a little bit more like a lawyer, so I'll give him that. I am not happy with this, though. I'm really not. It's hard for me as a non-legal person to look at this and say, you're having this whole hearing and all these experts talking about this one person, Summer, and you're not even going to let that person come and have her say? That's not cool, right? I don't think that's cool. However, that's the way the law works. It's the nature of the beast, exactly. So, yeah, that's how I feel about that. Becky Griffin says, Mark means making sense. Then someone else gave him from his argument. He watched Perry Mason. Yeah. Yep. Marie, I do agree with you. I mean, they're not talking about the children. They're not talking about this case. They are able to take this one argument, this one motion, and put it in a bubble and just discuss that, ignoring everything else. When John Pryor was going on and on and on about, this is egregious, I'm like, no, you know what's egregious? What Rob Wood said was egregious. The manner in which they found Tylee's remains. That was egregious. This is baloney. This is not egregious. Okay? So things like that gets me so riled up. And I think all of us kind of exploded in chat at the same time. Listening to that, listening to John Pryor go on and on about ethics and professionalism. And when wasn't he convicted? I forget exactly. He pled down to a lesser charge of sexually assaulting a 19-year-old client of his in his own office years ago. Right? Do not sit there and talk to me about ethics. Dude, and Mark means all this stuff about, well, he said this and he used religion and he da-da-da-da-da-da. Yeah, have you looked at your own Twitter account, pal? So the hypocrisy of this, I think, is what a lot of us are reacting to. This is really, really hypocritical of them. And that's frustrating. But, that's the way the world works right now, unfortunately. Kat says 2 things. You can always ask Summer to come on after the case. If I were Summer, I'd be offended by the supposition that my testimony would be changed by what Rob Wood said. Yep, Kat, I agree. I've always said since day one, and even when I was just doing stuff with Paul over on his channel, I would never interview a family or friends of anyone in an active, ongoing case, because the risk of impacting that case is too big. It's too great, and I don't want to gum up the works of justice. So I will never do that. As much as I want to, I'd love to have Summer on and see what she has to say, but it's just not the right thing to do. I don't want to get called into court. I don't want to have to deal with that. So no. But after the case, that's a whole different story. And Summer's testimony is not trustworthy anyhow. Sharon, you're absolutely right. Summer has not been the most honest of people. And we can tell that just from her interviews on TV and her statements on her social media. So there you go. However, I can see her watching the hearing and freaking out the other day. Like, what are they talking about? And being upset, being offended. Like, you think I don't have my own mind? That a 18-minute conversation with Rob Wood is going to make me completely change my mind? No. That's kind of a stretch, I think. Yep, the judge is going to rule according to law, not emotion. And that's how I try to approach these cases. I really do. If you watch my videos, I try to bring you the information, not get all profound about it. Here's what's happening. But this hearing has me angry. I cannot stand hypocrisy. I can't stand it. And the bluster that we see from John Pryor is very triggering. All right, which, that's a whole psychological thing for us to get into. But John Pryor triggers me with his arrogance, his hypocrisy, his attitude, his demeanor, his voice, all of it. John Pryor is a triggering creep. So there, I said it. Come for me, John Pryor. Apparently, they're aware that these hearings are all over YouTube and stuff. He mentioned that several times. If you're watching this one, Pryor, John has a Pryor. Yeah, I'll talk to you. I sure will, buddy. You're not going to like it, but I will talk to you. Yep. Let's see. Let's check on chat. My goodness. Of course, I just started to eat as soon as I decided to go to recess, because, of course, that's how this works. In actual fact, Summer lied to the FBI when she agreed with her mother about when JJ last called. Yep. Now, they'd have to prove that was a lie and they weren't just misremembering. But, for crying out loud. Danielle says, I just summed up how she feels about Pryor. Yeah, there's something about Pryor that's got a lot of our backs up personally, and we have to kind of remove that to analyze what's happening here. I don't think John Pryor's argument it was not as strong. I was far more swayed by what Mark Means said than what John Pryor said. Now, part of that could simply be from Pryor's attitude, which will be interesting going to trial. Imagine you're sitting there on the jury and you get John Pryor coming up, blah, 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 all his blusterfulness and whatever. You would probably be put off by that. I would be put off by him entirely, and I might not hear what he has to say. I might discount his witnesses, just like, no. Where Mark Means, I listened to what he said today. I actually, because there is none of that triggering feeling from him, I can actually listen to the words he's saying, and I was like, he's kind of got a point there. Right, so that's something that these two guys, if you're watching this trial, you should probably let Mark Means do the talking at trial, because Pryor, you just put people off. You do. The big red hopper. Oh, that's a person in chat. Okay, I was like, is that what we're calling John Pryor? No. Oh, two defense attorneys doing the job for their clients. Yep, that's what they're doing. I don't know if John Pryor lives in that house. I wouldn't think so. Gotke says he won't get to trial because these charges are going to fall away when murder charges come, if my crystal ball is to be trusted. That's possible. See, I kind of think that Wood might be wanting to get this trial and these charges settled first and then go for the conspiracy to commit murder stuff later, possibly, because then he certainly has some time, because if they're convicted and in jail for 5 or 10 years, he's got time to work up the murder case. But part of me was like, I'm watching this, I'm like, drop the murder charges today, just do it. I'm sick of these guys. So it's very hard to watch a hearing like this and not become emotionally involved. But I am quite irritated with John Pryor at this moment. I'm irritated with the judge because I don't know. For all the trials we've seen, judges don't usually let attorneys go on like this. They usually will say, okay, rein it in, or get to the point, or speed it up, or something like that. I was a little surprised by that. I am still a little upset about the summer thing. I understand, sure, it was last minute. Sure, they just filed that this morning. Yada, yada, yada. I get that. Well, I got to take my sweatshirt off. It's too hot in here. Oh, there we go. So I understand that, but at the same time, this is the person that they've been talking about this whole time. She should have her say. Just in fairness, I think Summer should have her say. Even though legally, yeah, they may have waited too long, etc. But so I'm irritated. I'm not happy with the judge. There are noises coming from the courtroom, but there are no pictures yet. So I will let you know as soon as anything happens. They should be back any minute now. The judge is being very passive, and I'm concerned what that's going to look like in trial. Is he going to let these lawyers run roughshod over the courtroom, or is he going to be able to rein it in? That's a big deal for me. All right, we're coming back, so I'm going to mute, and here we go.
Everybody's here after our mid-afternoon break. This is the time on this hearing where we are at the point of rebuttal argument, if any is requested. Mr. Pryor, I'd let you have your rebuttal first, and then Mr. Means in order of your closings. So Mr. Pryor, any rebuttal? And again, I'd ask counsel to not reiterate their closings, but just any rebuttal in light of the prosecution's argument. Mr. Pryor.
The first point that the prosecutor made is that somehow the Idaho rules of professional conduct don't apply in this case, and that it's the job of the Idaho State Bar Council to determine whether there should be any sanction for behavior. That is wholly and entirely inaccurate. A court, and there's a Supreme Court case, and I apologize, Judge, I don't have it at hand, but there is a Supreme Court case that is directly on point that says it is the inherent power of the court to take basically the job of being the gatekeeper of all the proceedings. Now, in this case, Judge, the allegations are Mr. Wood manipulated, intimidated, coerced, coached, whatever term you want to use, a material witness or a witness in this case. He affected and involved himself to an extent that it created a problem for us to have an impartial and fair trial for Mr. Daybell. It is not up to the state bar to make a decision on that, Judge. It's up to the court to make the decision. Now, what it is up to the Idaho Rules of Professional Conduct to do is to guide a lawyer in how he's supposed to conduct himself. And he's guided by the Idaho Rules of Professional Conduct and the rules that guide a prosecutor. Now, under 8.4, it tells you what misconduct is. And rather than go through it and belabor this point, Judge, it's very clear what misconduct is under 8.4 of the Idaho Rules of Professional Conduct. Mr. Wood's actions cannot be described as anything other than a violation of the Idaho Rules of Professional Conduct. He purposely and intentionally disparaged another attorney. He disparaged a defendant, and I agree with Mr. Means. He slightly disparaged me and slightly disparaged Ms. Vallow in his references. He used his authority as a prosecutor to manipulate and intimidate a witness. It doesn't matter whether it had an impact. Now, regards to the Weber standard that he's applying, what the prosecutor is attempting to do is throw a lot of cases out there and say, let's see if anything sticks. He talked about defense doing that, but that's exactly what he did. Because Dr. Newton expressly said there is not any case on point that directly shows what the standard should be and how this should be applied. But it's not a heightened standard, Judge. If we apply a heightened standard to everything that involves what a lawyer does in a case, there wouldn't be any discipline. And you don't draw an analogy in Weber because that was a trial, and during that trial, these things were conducted. This is a completely different situation. This is a case that before a witness gets in front of a police officer and before she gets to testify, this prosecutor spent 20 minutes massaging his theory. Now, Mr. Evans said, Mr. Means never said to Ms. Shiflett what to say. I beg to differ. And I asked the court to go back to the transcript, go back to the tape recording, and hear Mr. Wood in his own words, this is what I want. This is what I want. So quite honestly, Judge, he did say what he wanted Ms. Shiflett to say. I can't even fathom how this is not in any way a violation of the numerous rules of Idaho Rules of Professional Conduct. In regards to a criminal statute, Judge, it's a very broad statute. And as a defense attorney, I understand and I advise all of my clients that in no way should you do anything that could be construed as influencing, inferring, suggesting anything to a witness when you're a defendant in a case. And the fact of the matter is Mr. Newton, Dr. Newton, excuse me, Dr. Davidson, and Garrett Smith, all of them said, there is no doubt that this is coaching, this is influencing, and Judge, if it's coaching or influencing, Mr. Wood violated a criminal statute. Now, in conclusion, this pretrial taint hearing, Judge, I'm going to suggest a pretrial taint hearing too, Judge, but that's going to be after I suggest my remedy that Mr. Wood get removed from this case. And I reiterate, I want him removed from this case. And then I'm going to gather every witness that's involved in this case and request the court do a pre-taint hearing on every witness. And Mr. Wood will be called and subpoenaed as a witness in every one of those pre-taint hearings.
I'm going to object. This is off what we're talking about today.
Oh, we talked about Judge, we talked about a pre-taint hearing and I get to address that.
You can address that, but we are just, well, it's part of your argument. So go ahead, Mr. Pryor.
And Judge, I'm going to call all of the witnesses and I'm going to call Mr. Wood and I'm going to get him on the stand under oath and we're going to talk about what was discussed. Because quite honestly,
but Mr. Pryor, this is not really an argument now at this point. You're just indicating a procedure you're going to follow in the future. So please just keep it to a legal argument if you would.
Well, the procedure simply is a reason and justification for what has transpired here.
I understand.
As all due respect, as Professor Newton expressed, Mr. Wood got caught. And because there isn't any case law is because it's the rare situation that a prosecutor would be so audacious and so arrogant to engage in this kind of conduct. And I find it outrageous. And my experience, and I hate to say this, is because I don't want it held against me in the future in Ada or Canyon County, but the prosecutors that I deal with in Ada and Canyon County are incredibly reputable, distinguished, and responsible prosecutors who take their job very seriously. And I can't understand how a prosecutor in a very high-profile case could even consider engaging in this kind of conduct. And it can only be attributed to the arrogance that he thought he could get away with this. He got caught. And I want some assurance from the court at some point that none of the other witnesses have been influenced this way. None of the other influences have been subjected to Mr. Wood's version of meet and greet. And I'm not sure how we're going to do that. But the first step, Judge, is to remove him from this case, because there is no other way you can assure my client, Mr. Daybell, is going to get a fair trial. Thank you, Judge. Thank you.
Thank you, Mr. Pryor. Mr. Means, any rebuttal argument?
Yes, Your Honor. Thank you. A couple things. In looking at the transcript that was admitted with this court, it's clear and beyond question that the statements of the prosecutor to this witness were intended exactly to get what he wants to hear. He says things such as, but I kind of want to give one thing I'm going to kind of ask you to consider. So what I want to kind of tell, and then what I kind of want to give you. I mean, these are all that the court can review these things, but there is no question. And the argument by the prosecution that the legal conclusion is that there is no evidence showing coercion or tampering or coaching or whatever standard or whatever one we want to throw is completely unsupported. The only evidence that was introduced at the trial is the exact opposite of that conclusion. There is no cross-examination or no counter witness or anything that supports the conclusions other than Dr. Davison, Dr. Newton, and the arguments that have been presented. So the court, in considering the evidence, is pretty clear. I think part of the mention or part of their brief that I mentioned before, red herrings, is pretty obvious on their argument. You cannot argue the ABA applies and then it doesn't apply. You cannot argue that the test applies, but it's limited to trial. But by the way, judge applied this same exact test. You can't argue that the waiver applies in a civil case with a civil attorney when a prosecutor has a higher duty of ethical standards to ensure justice as a quasi-judicial officer and compare that to a typical incompetent civil attorney. You cannot argue that Rule 16, that object to the argument and then argue in your brief that it hasn't been violated. If we look at Rule 16 by opening from their argument and their oral argument on page 8 of their brief, it's real clear. Rule 16A, mandatory disclosures of a prosecutor. A prosecutor must disclose to the defendant information in the prosecuting attorney's possession or control, or that later comes in the prosecuting attorney's possession or control that tends to negate the guilt of the accused or the offense charged, or that would tend to reduce the punishment for the offense. When we look at the recording and the transcript submitted in this case by stipulation of the parties, the prosecutor expresses his own opinions that there is information and evidence that he has that negates and potentially affects the punishment for my client. This information was withheld and has not been produced absent the recording that we received and provided to the court. That is clear. When we flip over to, in the same rule portion of 6, state witnesses, down toward the middle portion, the rule says the prosecuting attorney must also furnish on written request, which we've requested multiple times, the statements made by the prosecution witnesses or prospective prosecution witnesses to the prosecuting attorney or the prosecuting attorney's agents or to any official involved in the investigation of the case, unless a protective order is issued. There is no logical argument that the 18-minute conversation that this prosecutor had with Summer Shiflett are statements by this witness. And again, we would not have this without production from Mr. Garrett Smith. It was not included in discovery responses. It was not produced despite it happening in October and this hearing now happening in January. The prosecutor, even if he didn't record the hearing, held in his hands statements by this witness. He had multiple opportunity, resources, and the sole obligation of everybody involved in this case to produce these witness statements. He withheld them. Despite his opportunity, he provided discovery responses on or about December 2nd of 2020. In no way are these statements by this witnesses included in those discovery responses. They were withheld. That end of Rule 16 allows this court to issue appropriate sanctions as a result of those violations. I think the sanction has to be at this point in time, when combined with the other issues here, disqualification from this case. And then if we finally look at Rule 8.4, misconduct of the Idaho rules of professional responsibilities, there's a violation of A, B, C, and D. This prosecutor engaged, if you look at D, engaged in conduct that is prejudicial to the administration of justice. No question about it. In C, engaged in conduct involving dishonesty, fraud, deceit, or misrepresentation. Committed a criminal act, and then it goes on. Violates or attempts to violate the rules of professional conduct. So the standard on 8.4 is not even did he violate the rule, he attempted to violate the rule. These are all problems that I think fall well within the discretion of this court to order Mr. Wood be disqualified from this case. Thank you, Your Honor.
All right, thank you, Mr. Means. That'll conclude the arguments on the motions. Council, I'm going to take a little bit of time here to get my thoughts together on a ruling. I am prepared to make a ruling on this afternoon, but I need a little time in order to put that together. So apologies for dragging this out potentially longer than necessary, but I'm going to take a break for about an hour, and then we will come back on the record at 4:30, and I'll make a decision at that time. So we'll be in recess until then.
Thank you, Your Honor.
Thank you.
Oh my God. Really? All right, so that was the end of closings. I have sent a StreamYard link to Lori Hellis if she's around. Hopefully she can come on and we can talk about some of the legal aspects of what's going on here in a very calm and measured way instead of me just being all crazy about it because I'm mad. We'll see. All right, so we've got an hour. I might as well just stay live. I may take 5 minutes and run to the bathroom, but oh man, listening to Pryor, his rebuttal, I didn't get a lot of legal argument out of it. I just got a lot of anger and a lot of that same feeling from earlier. He reminds me a lot of my ex, my narcissist ex, when he would be caught doing something and trying to be like, they didn't do that to me. Oh, the outrage. Oh my goodness. Oh, such righteousness, such, oh, I'm just aghast. Oh, that sort of attitude, that drives me bananas. Absolutely drives me bananas. So, ugh. That's all I can hear when he opens his mouth. I don't hear any words he's saying. All right. So if he said anything really important, I probably missed it because I'm just sitting here just like, ugh, yuck, that's a problem. That is a problem because that is going to transfer to some members of the jury, no doubt. Okay, no doubt. So hopefully they will get on that and rein that in a little bit. But yeah, that righteous indignation and that there's that tone of voice. It's so specific, is it not? Anyone who's been through that, it is so specific. Once you hear it, you will never unhear it. All right, so that's all I got from Pryor. Mark Means, I think he rambled a little bit, but he didn't really seem to add anything different that we hadn't already heard before. So now it's going to come down to the judge. Yeah, Dana, that's a good point. Pryor did kind of, it felt like he was threatening the court. If you don't take him off this case, then I'm going to have a pretrial taint conference on every single witness. And I'm going to call this person and I'm going to call that and I'm going to do this. And even the judge is like, whoa, slow your roll, but the judge's like, yeah, okay, go ahead, continue. First he said continue, then he objected again and the judge kind of reined it in. But it's definitely that blustery, well, you're not going to like what I do if you don't do this kind of attitude that's just really, really off-putting and really unprofessional. I have a hard time with the judge that sits there and lets him talk to him like that. You're addressing the judge. You may not be sitting in an actual courtroom, but you're still in court and you're addressing the judge like that. That's not okay. Not okay. For all of these people being all worried about professionalism, to sit there and talk to the judge like that was just, I don't get it, man. I don't get it. So yeah. Oh, and my husband was in chat, expat Mara. I hope he saw my comment. I'm triggered. Bring home the chocolate and alcohol. Hopefully he will, because sheesh. Yeah. Yeah, he was very condescending, very patronizing, very blustery, very threatening. Justina, I agree. I do think Judge Boyce is a little too laid back. Even if, legal arguments notwithstanding, you still address the court properly. You don't address the court like that. I haven't seen many lawyers get away with that. The last lawyer that I saw that I thought was incredibly rude was the Mullinator from the Rosenbaum trial. But she was more rude towards the people on the stand, the witnesses, than the judge. Even she toned down her rhetoric for the judge and came off to the judge as very, oh, I'm sorry, judge. Even the opposite way. Oh, I'm sorry, judge. Oh, she turned it the other way. So, man, this is just crazy. It is. It's very hard to do. Yeah, I'm a little triggered by this. So what do you think is going to happen? Let me take some time and talk to chat since we got an hour to kill. My goodness. What do you think the judge is going to do when he comes back? What do you think? Julia says she thinks this is the wrong judge for this case. Jennifer says, hope he'll start getting annoyed with Pryor and Means in trial. Oh. Remember that Pryor did threaten that there are a lot more of these issues to come up. He's going to raise more issues like this. So, and he threatened if Rob Wood stays on the case, we will have a pretrial taint hearing for every single witness. What that is they will call the witness, they will bring them before the judge, and they will say, have you been influenced or has your testimony been tainted in any way by the prosecuting attorney? For every witness. That'll be something. I would think by then that Judge Boyce would be really irritated by them, but we'll see. We'll see. Feeding It says, I hope he'll realize the foundation. This was not an interview interrogation. See, that still seems to be lost in this whole mess. So maybe it's us. All right. Because these are all lawyers here. The judge certainly well-versed in law. None of them seem to be really pointing out that this was just a meet and greet, not an actual interview or deposition or anything. So maybe it's just us reading way more into that than we should. That's possible. We'll have to get an answer from Lori Hellis if she's around. That would be a good question to ask. But Sophie says she missed it. You didn't miss much, Sophie. We should be getting a ruling from the lawyer in about an hour. They shall. So I'm going to be shocked if seasoned chief law enforcement officer in this county, stellar record, is booted because of Mutt and Jeff demand it. Yeah. Now, this morning, I would have said there's not a chance in heck that Rob Wood is going to get removed from the case. Not a chance. But the judge's rulings today on all the motions that came up, some of the things that Mark Amin said, and Evans's rather lackluster defense have me pretty worried, to be honest. Are you guys feeling worried about this or what? The judge seems afraid of the case, possibly. Daybell might have more property that Pryor has an eye on. Andrew says the judge is going to deny this. I really hope so. They were talking about precedent. Okay. There is no, apparently, in Idaho, precedent for removing a prosecutor in a situation like this. Now, I don't think that Judge Boyce is bold enough to want to set that precedent for removing a special cross prosecutor from a case based on a private one-on-one, allegedly, well, supposedly, from a private conversation. I won't say one-on-one because there were other people there, but removing a prosecutor from a case based on a private meet and greet conversation that was surreptitiously recorded by that person's attorney who let the entire conversation happen anyway. That seems like a pretty dangerous precedent to set, because imagine how easy it would be going forward with that precedent set for any defense attorney to play the same cards. And you could just, boom, just pop off the prosecutors like flies. Nope. Look at a legal precedent. Do. That really seems a dangerous precedent to me for Judge Boyce to be willing to set. He's not even willing to stand up to people in his own courtroom. But yet he would be setting a legal precedent going forward for that. I don't think he's going to do that. I don't. Hopefully that's what he's thinking about right now. Because when the judge makes a ruling, he's making his ruling based on decades, centuries of legal history and precedents. When he does something new and different that hasn't been done before, he's setting the precedent, and he'll be remembered for that, whether positively or negatively. So, Miss Wee Lassie says, I do wonder if Evans is relying on the incompetent behavior of Means and Pryor to shine through and show how feeble their case is. It's too late now. He's given his closing, Hold on one second. Okay, sorry. Jess says she's more worried that Wood didn't send the discovery of this meeting. Yeah. See, But, I have questions about that, and I'll need Lori Hallis to help me answer that. If this was an informal meet and greet, there wouldn't be discovery of this meeting. This was a conversation that they had. Right? Rob Wood didn't record it for posterity or for the record. He probably thought they were just talking off the record. It seems that he didn't know that Smith was recording it. It wasn't an actual interview. It wasn't a sit-down deposition. It wasn't anything like that. So maybe there shouldn't even have been a discovery or a file for this meeting. And that's probably what Wood is thinking. Like, of course I didn't deliver it in discovery because it wasn't a thing. Now, if Rob Wood had called her into his office for a deposition, of course he would have had to give that over for discovery. Absolutely. But that's not what happened here. Let's see. It sounds like entrapment. It sounds a little strange. Oh, the judge is probably taking an hour now. Summer wanted to be needed by Wood. To her, it's just another guy wanting her and getting attention. Denise, that's a possibility. I don't know that for sure. Why does the judge let Means ramble? Well, it seems to me, at least in the course of this hearing, both days, the judge let Pryor wander way more than Means did. Why? See, that's a question that we've all asked a lot today, Josette. Is this judge does seem to be a little lenient with that kind of thing in ways that other judges we've watched have not. So, that could be a thing. I'm just checking. I would really still like to see if they're going to post that affidavit of Mindy Gee and Summer. I would like to see that. Nothing posted yet. They might not post it since it wasn't introduced formally into court, but I would like to see what Summer's going to say. Pryor picked up on that judge. I think Pryor pegged this judge as, oh, he's going to let me do whatever I want. Haha. And so he just went for it. But, Teresa Davis says, you don't have a good feeling about this. Yeah, I'm a little nervous, but I really don't think the judge is going to remove Wood. I don't think they proved anything. They certainly didn't prove a motivation. They didn't. So, I really hope the judge denies this. Who is Mindy Gee? Yeah, I was showing you that before they came back. Let me get that back open. 1 second, and I will show you who Mindy Gee is. Give me 1 second. Of course, when you need it, Facebook decides they're going to be super slow. All right, let me put it on the screen. This was sent to me and also shared by Justin, I believe, the indomitable Justin Lum. All right, let me get this bigger so you can read it, and I'll read it for you. What it says, Mindy Gee is an associate at the Corporate Litigation and Counseling Practice Group. She is a graduate of William & Mary Law School, where she was the recipient of the Virginia Mr. Scholarship and Public Service Fellowship. Ms. Gee served as a notes editor for the William & Mary Law Review. Prior to law school, Ms. Gee was an international affairs specialist at the Office of International Affairs and the Criminal Division of the U.S. Department of Justice, where she handled casework involving extraditions and mutual legal assistance matters in the Middle East, Asia, and Africa. At OIA, Ms. Gee worked extensively with prosecutors, federal law enforcement agencies, and foreign central authorities on international evidence-sharing matters. In 2015, she was the recipient of the U.S. Marshals Service Certificate of Recognition for her efforts in the extradition of a 15 most wanted fugitive. Ms. Gee is fluent in Korean and holds a BA in English from Yale University. So that's kind of impressive. I think that's pretty impressive. And that's who they wanted to bring to the stand. The state wanted to call her because it goes back on the thing. The state wanted to call her to the stand to testify to something that she had heard from Summer or something that she witnessed while she was there at the meeting that Wood had with Summer, something like that. We don't know for sure because we do not have the document yet. If it comes out, we're certainly going to go over it, though. So, yeah, that's who Ms. Gee is. So, certainly, I believe that Evans asserted that she was highly qualified and trustworthy. Yeah, those accolades would make me think she was pretty trustworthy, too. Yes, far better than Dr. Newton. I'd rather listen to Mindy Gee for 3 hours than Samuel Newton again, for sure. So, but did y'all find it as strange as I did that when they got back and they started talking about, letting Summer testify, how adamant and almost over the top Pryor and Means both were about not letting her come in? And I'm thinking, if you think your case is so strong and you really believe that Rob Wood did this, why would you not want Summer to testify? She could only help your case, right? But no, they freaked out. They did not want her on that stand come love or money. They were like, no. Why would they react that? There's only one reason that they would react like that is because they knew that she would destroy their argument. 100%. So, I don't know, I know the judge has to go on logic and the law. I would have liked to say, oh, you seem scared. Huh. Let's get her up here and see why. This is why I'm not a judge. But yeah. Yes, Jess, that's a good point. At one point, Pryor was saying that he apologized to the court for his temperament from yesterday. I'm like, what happened yesterday? But he also referred to the first day of the hearing as yesterday later on, too. So maybe he's just really confused. I don't know. But his temperament was no better today. So, what is that thing? People apologize without changing the behavior. It's not really an apology. So consider that, John Pryor. John has a Pryor. Goodness gracious. Yeah, it makes me think that they knew it would be a problem for their argument. Absolutely. So I agree with that 100%. Dana says, yes, they were afraid of what she was going to say. She was going to say Wood didn't influence her testimony. Mm-hmm. Yep. I think she might have said a whole lot more than that, too. I wonder if Summer will bring a private case against Means Pryor Garrett. I don't know if she can. I don't know if there's any, legal thing that she could do there. But if there is, I hope she does. So the judge ruled on what Gee's statement could be read or said. So has he read it? No, he ruled that a lot of it would be hearsay and he would only have allowed part of it or something. So they didn't even bother with it. So, but it's interesting to me because I know in some situations, like a preliminary hearing in some cases, the hearsay rules are much more lax. So I was hoping that would have counted here, but Yep, Jess Nelson, who has the YouTube channel Know Better, Do Better with Jess, which you also subscribe to. It's wonderful. Mods, if you could link to that, that'd be great. One of Jess's famous statements is an apology without change is manipulation. That's so true. And that's what we saw from John Pryor today. That's what we see from John Pryor a lot. Man. So yeah, I have a hard time really focusing on Pryor's legal argument because I can't get past his demeanor. It's so off-putting that I just want him to be quiet and go away. I really do. You know, I think a lot of other people do too. So, anyway, what's going on? Since we've got quite a bit of time before this case starts again. Let's see. I can't find Lori Hellis. I have sent her a link to StreamYard. I would love to get around to answer some questions. Lori Hellis, if you're around and you want to come on and chit chat, that would be wonderful. I know she's still listening. She might be running for a break now that we have a nice long lunchtime. There's a link to Jess Nelson's channel. Please check it out. It's very good. When you need that uplifting minute, that's the place to go. It's wonderful. Miss B. Lassie says, but if they misconstrued her chat with Wood and demeaned her by bringing out salacious lies or defamed her, it's possible. I think that's really legal gray area. I don't know enough about defamation or slander and libel laws like that to know if she would have a case, but hopefully she's got a new lawyer who's looking at it. Mm-hmm. Can I do a brief rundown on what happened? Yeah, just let me have a drink first. It's really dry in here. All right. The other day, 2 days ago, we began this hearing, the oral arguments on the motion to disqualify Special Prosecutor Rob Wood from the case. This was brought by Mark Means first, and then also brought by John Pryor. So when we began the hearing with the witness of Garrett Smith. Garrett Smith is a lawyer who has represented Melanie Pulowski in the past, also represented Summer Shiflett and Zulema Pastenes, and he surreptitiously recorded a meet and greet conversation that Summer Shiflett had with Rob Wood. And then in August of this year, he delivered that recording to Mark Means, right? And he said that he delivered it to Mark Means because of, and I quote, the unprofessional statements made by Rob Wood about the defense attorney, Mark Means. Right. So he gave the tape to Mark Means. He says because Rob Wood said some mean things about Mark Means. Oh, boo-hoo. Right. So So they bring this motion. Mark Means files this motion to have Rob Wood disqualified, and he has 6 main points, one of which is he alleges a Brady violation, which that's just crazy. And 5 other reasons why this audio recording shows that Rob Wood should be removed. Now, they played the audio recording in court, and there are some things that, okay, maybe Rob Wood shouldn't have said. Maybe he shouldn't have told Summer that he was going to bring murder charges. Maybe he shouldn't have told her that, well, we don't want it to be a capital case or death penalty case. That depends on Lori. Maybe he shouldn't have said those things. Possibly. Now, is that an actual legal thing, or just maybe he really shouldn't have said them? That's what this hearing is to determine. All right. So there's a whole lot of garbage going on with the witnesses that were called by Means and Pryor. One was a forensic psychologist and one was a law professor, trying to outline all of the statements that Rob Wood made in that conversation and showing why they legally warrant having him removed from the case. Right? And that was a very painful 7 or 8 hours we sat through the other day. Today we had closing arguments, and now we are just waiting for the judge to return and hopefully make his ruling from the bench. We did have a bunch of motions filed this morning, including the fact that the state wanted to have Summer Shiflett testify, as well as a woman named Mindy Gee. But the judge did not allow that, basically because of the timing. Right? Evans did have time to put them forth sooner, unless Summer just reached out yesterday and was like, hey, wait a minute. I need to tell my side. This is not right. So, and that's it. Now we are just waiting. Yes, quite honestly, Judge. Oh, man. The Brady violation is moot because Wood did not have or know about the recording. Yep. And Wood did not record it himself for his own record. If he had, okay, maybe they might have a Brady argument, but probably not, because this was not, like I said, a formal sit-down interview or deposition or anything like that. Did I notice that Pryor kept calling Rob Wood Mr. Means? That was weird. I've been doing that too, though. I get all these names in my head, and I start calling everybody everything. So I kind of get that. I'm going to try to make more coffee and get down another slice of key lime pie. Ooh, that sounds good, Flame Lily. Mr. Daybell had 2 children buried in his yard. What was fair about that? Exactly, Betty Boop. I think that's why we're all sitting here still. That's why we're all kind of up in arms, because it feels like John Pryor was getting so upset. Oh, how could Rob Wood violate these ethics? Oh, the humanity. Oh, clutch my pearls, as Paul would say. But the fact that there are 2 minor children buried in his client's backyard is no big deal. That's a hard pill to swallow. It really is. And it's hard to see somebody get up and argue with that much vigor over something like this, but yet defend somebody from something like that. It makes me a little cranky. I got to say, definitely makes me cranky. Hold on a second. I got to pour a soda. I am so thirsty. All right, so we should take bets on what the judge is going to do. I'm going to say that he will not remove Rob Wood from the case, mainly because of the precedent issue that I mentioned before. That's my guess. Does anyone here think that he will remove Rob Wood and that there's actual cause for that? Or do we all think it's just a bunch of baloney? Sorry about that. So did it sound like a commercial? Oh, man. Cassidy, you think he's going to remove Rob Wood? It's very hard. In this case, all of us watching, or most of us, are very emotionally invested in the case because of our affection for the children and their family. Certainly, family like Kay and Larry, I mean. And we want to see what we think is best happen. I like Rob Wood. I would like to see him stay. Is that legally the best thing? I can't say that for sure. I really can't. And I hate that. So, but even if Rob Wood is removed, the case doesn't stop. Right? The case doesn't get tossed out into the woods, I don't think. I'm pretty sure it will continue with a new prosecutor. So it's not the end of the world, It's not. I don't think the judge will get rid of him, okay? I don't think he'll remove him, but I think the judge is being quiet till the end. The defense is doing a good job to make people even more antagonistic against them and their clients. That is true, Karen. They should consider, and maybe they did consider and thought it was worth it, the fallout from behavior like this. Certainly, John Pryor is well cognizant of the fact that this is being broadcast on YouTube and other places, and people are watching them. This is not winning them a lot of fans. I wish Lori H was here. I don't have enough. Yeah, I do too. I do too. Oh. ACM, is it common practice that when the defense has no defense, they try to get the prosecutors disqualified to mess with the case? I don't know how common this is. We don't hear this very often. I think there are maybe 3 or 4 cases the last couple of years where I've seen it happen. And in none of those cases was the prosecutor removed. So, I don't think it happens very often. Teresa Davis says, I have such a dislike for Pryor that I couldn't sit in a jury with him as a lawyer. I have sat on juries when I could be impartial, but not with him. You know, Teresa, I'm going to say the same thing. Although I pride myself on my impartiality for cases. But that guy just, he triggers me too much. I could not sit in the courtroom. I couldn't do it. Mm-hmm. Lori Hellis is here. She's reviewing the closing while we wait for the judge. Awesome. Fantastic. Lori, I did send you a link to StreamYard. So if you ever want to pop on, just click that and it will take you right into it. And I'll bring you right on. Then we can talk. Just Robbie says, I agree with both of you guys. Pryor's like nails on a chalkboard. Very triggering, almost whiny. Mm-hmm. Yes, he is. I'm surprised the defense calls Lori by Vallow instead of Daybell. He tripped up there a little bit. Mark was like, Lori, Mrs. Vallow, Daybell, person. Yeah. Mm-hmm. I think there's still a lot of confusion. Whenever we look at the court filings, it says Ms. MS, Lori Noreen Vallow, Daybell in parentheses. So, what? All right. It's almost like Lori wants to be Lori Daybell, but Chad is like, no. You know, do you get the feeling? I get the feeling that Chad is kind of pulling away from this whole Mrs. Daybell thing. That's the feeling I get. Certainly when I listen to Pryor, some of the things he said have made me think maybe they're getting ready to distance Chad from Lori. You know, but bottom line is those kids were in Chad's backyard, not Lori's. So distance all you want, my friend. It's not going to mean too much at the end of the day. Jess Nelson said that he's easier to listen to if you picture him as a Little Caesar guy. Yep. Jess and I are talking about doing a bad lip reading version of the hearing. I'll pull the video down and we'll add our own voices over the top to make our own hearing. Do bad lip reading. I think that would be hilarious and something to make me feel a little less angry. I'm pretty angry. Oh, that would be fun. Right, Lori didn't even have a backyard. Yep. Can we talk about how creeped out one would be living in that house knowing the bodies were buried in the yard? I could never live it. Now, okay, I like ghosty stuff and ghost stories. I could never live in that house where those children were buried in the yard. So what is John Pryor going to do? He's probably going to sell it to try and make money. Because, you know, he's not really getting paid for this, I don't think. I think Chad had, what, at the time of Lori's arrest, didn't we know that Chad had like $100,000 in the bank? So Pryor's probably got that already, you know, if that was even left. Oh, and Kresha, welcome back. How are you holding up? I know this has got to be frustrating for you too. But man, we're all a little nervous over here. We're hoping for the best when the judge gets back. Yep, Jess, that's what I would do. I would bulldoze it. I would make a memorial site, and that would be the end of that. I don't think anybody should live there. I certainly wouldn't want to own it. How is Lori paying? Stitchy, we don't know. We have no idea how Lori is paying. We don't know if she is. Mark Means could be doing it pro bono. He could just be doing it because he thinks she's pretty. Who knows? Who knows? Maybe Lori's family is paying for it, you know? Stop slurping your soda. It's obnoxious. My twin boys have better manners. Shauna, I'm going to slurp my soda because I'm freaking thirsty and I've been sitting here for 3 hours. And when you sit somewhere talking for 3 hours, you get thirsty. And when I get thirsty, I have a drink. So I'm sorry you are so utterly offended by that, but, you know, go watch it somewhere else. And with that, I shall slurp my soda again. Because, you know, sheesh. Anyway, put an animal park there. You put something there that JJ and Tylee would have liked. A playground or something like that. That would be cool. Did I notice in the hearing 2 days ago, allegedly, that there was testimony that Chad asked Summer to deal with bail? I don't. I think I must have missed that. I'll have to go back and listen. That would be interesting. Definitely. Yeah, because I do think that Summer has a much deeper involvement than we know so far. you know. I'm just checking StreamYard. Yeah, I do think that she's more involved with them, meaning Chad and Lori. We do know now that she went to some Preparing a People events, or at least one. We know that she was involved somehow with Alex, and back when they were at Lori's house in Arizona, maybe she had contact with Chad. So, I think Summer is maybe more involved than we've found out so far. That's quite possible, which is why maybe she got so upset and wanted to speak to the court today. And it did seem like she reached out to Rob Wood, not to the defense attorneys. So, yeah, we can only infer so much from that, but it's still a pretty big inference, is it not? Maybe Lori had to sign over power of attorney to Summer on her behalf for financial matters while she's incarcerated, possibly. Although I think, wouldn't her lawyer do that? I don't know how that works. That's a really good question. Summer must have had something large to voice. They were terrified. Yeah, Cynthia, they really were. They kind of went nuts, meaning Mark Means and John Has a Prior went nuts thinking that Summer might want to testify. They wanted to shut that down so fast. Yeesh. Yeah. That's why, see, it's the more salacious side of me that wants to know what Summer would have said. I think she would have said, I didn't know he was recording it. They never told me. They didn't even tell me they were going to bring this up in this motion. And now I have to hear about it watching Facebook. What on earth? And I think she would have been pissed off. So that is probably why they didn't want her to talk. And certainly that wouldn't have killed their argument entirely from the legal perspective, because they can try to prove that he was coercing her even if she didn't catch on. You know what I mean? But it certainly would have made them look terrible. Absolutely terrible. It'd be funny if she testifies that the lawyer set it up, not her. Yep, that would be. Yeah, because remember, we don't know at this point in time. We don't know for sure whether Summer reached out to Rob Wood or Rob Wood reached out to Summer, or if maybe Garrett Smith reached out to Rob Wood and then turned around and told Summer, oh, guess what? Rob Wood wants to talk to you. You know what I mean? I wouldn't be surprised to find that out either. So, exactly. As told by Thielen says, there is a reason they do not want Summer to talk. What that reason is, we don't know, but it's there. And boy, I would like to know. I'm sure Rob Wood knows. Maybe he'll tell us. Not likely, but why did the state avoid that topic? Which topic, Lay? Or Lee? Sorry if I'm pronouncing that wrong. I'm not sure which topic. Summer went fishing with Wood. I wonder if Pryor will try and block Summer from being a witness. All I know, I've seen Summer's name on a witness list that was given by Mark Means. So that may change, because if she's angry now, she may not want to testify, or maybe called as a hostile witness for Mark Means. That would be interesting. Oh, about who contacted whom. I'm not sure why they didn't bring that. See, there's a lot of little things that I think are things. Sorry. Ow. I'm sorry. There are a lot of little things that I think are things that they're not making things out of, if that makes sense. Like the fact that this was a meet and greet conversation, informal, right? I think that's a big deal. And who contacted who first? I think that's a big deal. And whether or not Mr. What's his name? Mr. Garrett Smith actually told Rob Wood he was recording it or not. I think those things are big deals. Why did Evans not make big deals out of them? Then again, he knows way more about the law than I do, so there's probably a legal reason why they're not actually big deals. But to me, it's a big deal. Does Summer have Facebook, Instagram? Yes, she does. She has all those things. So yeah, my phone was on. I still have my Christmas sounds on my phone. I still have the Christmas background up on StreamYard. I can't get rid of Christmas yet. It's sad. I was annoyed by Pryor pointing his finger. Yeah. his whole demeanor, everything about his demeanor, his body language, his tone of voice, his facial expressions was absolutely annoying, Jackie. How much champagne do you need to put the bells on? I can be bribed with very little amount of champagne. The judge might have it. Yep, hostile witnesses are great. You can lead them. Ridgeback GMA. Hi, how are you today? Good to see you here. You were annoyed by Pryor looking at his watch. Yeah. Didn't it looked to me when the few times I caught him glancing down at watch, it looked like he wasn't even wearing one. I have to go back and check, but I was like, are you looking at an imaginary watch? Like you're like, come on, hurry it up. How annoying. Tastefully true. I wonder if Summer got a deal like Zulema and is putting it in jeopardy. I think if Summer had a deal, we probably would have heard that. They would have probably had to have mentioned that when debating having her on today. So I don't know. She might not. See, I don't think Summer would have been in a position to have done anything incriminating, so she would need a deal. Zulema, on the other hand, that's a different story. I'm trying very hard not to yawn, Tammy. Maybe Lori asked her to go see him in an attempt to find out how much evidence he had in her. Judy, absolutely. That is quite possible. Lori could have called Summer and be like, hey, I want you to go talk to Rob Wood. Now, Rob Wood did mention, was it Rob Wood? Or actually, I think it was one of the defense witnesses mentioned a phone call between Lori and Summer. They mentioned that earlier in the hearing. I would love to hear that phone call, wouldn't you? That could be some stuff. And remember, any phone call Lori had from jail with someone like that, they are recorded. So that would be interesting. Summer was asking questions about cause of death and autopsy. Yes, she was. Summer was asking a lot of big questions about this case, So the question is, was she doing it as the aunt of children who had been murdered, or was she doing it as the sister of Lori Vallow to gain information on the case? We don't know that. But given that, it is a little strange that Rob Wood gave her so much information, don't you think? I mean, just a little strange because, he mentioned that he was going to be very forthright, He mentioned that he was not going to, what did he say? He said he wasn't going to pull any punches, right? He was going to be very straight. Like, yeah, I'm going to bring conspiracy to commit murder charges. Yeah, it could be a death penalty case. Tim, it was very matter of fact. But at the same time, it's like, maybe you're telling her a little too much, because he had to have known at some point she would talk to the defense as well, especially being Lori's sister. But I don't think that's manipulative. I think maybe that's just him talking a little too much. Bethany says, can we talk about how Pryor said the word massage? Yeah, that was not good. That was not good at all. Wood was trying to build goodwill and get her to think about the children. I agree, Cheese Factor. I think he was trying to make a connection to her, building rapport with her, but then also trying to say, hey, this is about the kids. This is really bad. And I think he was trying to let her know that this was really bad. This isn't a case that Lori was just going to slide out of by batting her eyelashes. This is serious now. This was big time. That's the impression that I got from their conversation, where Lori is probably very used to getting out of trouble by batting her eyelashes, like we saw with the Chandler, Arizona Police Department. And so probably Rob Wood, the impression I got was he was like, hey, I know you're used to your sister doing whatever the heck she wants and never getting called to task for it, but this is different. This is serious now. Tastefully, it's not a fact. It is a rumor that I've seen, and it's pretty widespread, but it's not verified or verifiable, really, unless Summer herself comes out and says so. Or somebody else that was there says so, like Colby, perhaps. Yeah, we don't know exactly who was there. It would be interesting to see. I would guess that Melanie Gibb was probably there. Mason Cowell might have been there because he was in the area. So it would be a very interesting party list to look at for sure. How close to Lori is she? It might be crossing her mind blood doesn't hold much weight with her sister. It's possible. I think she's much closer to Lori than she would want us to believe. But all this, it is going to come out in the wash. So, they can try to keep her from speaking at hearings like this all they want, but eventually we'll get to hear some her side of things. Let's see. Not listening to him anymore. Mason Cow. That's who I call Jason Mao. I've heard him as Mason Cow. I wonder if Lori was able to dye her gray roots. You never know. I don't know how jail works. Never been. Don't plan on going. I don't know if you can dye your hair. Who is at the pool party for sure? Andrea, we do not know. There's very little reference to the pool party as far as official documentation. So a lot of it is anecdotal. So we don't know absolutely for sure. Certainly, I would trust Colby's word on who he said was there, things like that. But until I see it in an official document entered into the court proceedings, I'm like, we don't know. So I know who I think was there, but that's it. All the Coxes want you to think they are as they appear, not as they are. Layshell, that there is a big trend in that direction with that family for sure. Although if you watch the documentary, the Investigation Discovery Channel had a documentary about a week or two ago called Doomsday about the missing children. And Adam Cox was in there, and Zach Cox was also made an appearance in that documentary. And they seem to have broken away from the main body of the Cox family. So, I liked what they had to say. They seemed very honest, and they seemed to just be like, why are people, what is going on? How can people not see what's happening? Jess says that we better stay in separate states if I'm not up for a good jail run. Oh, it would depend if Paul's willing to come bail us out, Jess. I'm not sure he would. Oh. If Wood is dismissed, he can still assist in the case behind the scenes. I'm not entirely sure. I believe that if he's removed as special prosecutor, he can still be on the team. He just won't be first chair. Though I don't know for sure. I don't know if the defense can ask for him to completely removed. Remember that Mark Means did file a motion for protective judicial order that would have barred Rob Wood from accessing documents, talking to witnesses, having anything to do with the case at all. The judge denied that, but perhaps if Judge Boyce rules to remove him, that they could take that up again. So I don't know how that works. That's another question to put on the Lori Hellis question list. See, Pryor knows all about ethical conduct as an attorney. That he does. My understanding is that the pool party had the police called. Hopefully there'll be a record. Yeah, there's when I went to do digging about the pool party, I wanted to find statements on it. I think I only found one statement that there even was a pool party. And it was a conversational statement. It was not something that's been introduced to court. It's not something that's, in any main evidentiary body of work. So we don't even know for sure that it happened. I'm assuming it did, but, so we have to take all that with a grain of salt. Do you think Jason Mao was interrogated? I don't think it was interrogated. Remember, an interrogation is a questioning session by the law enforcement where they are trying to elicit a confession. That's a very specific type of questioning. I don't think he was interrogated at all. Was he questioned? I don't know. I can't imagine that they wouldn't have questioned him, but I've never seen his name on a witness list so far. We've never seen any statements from him. I think that's very strange. Certainly Melanie Gibb throws his name around like, it's worth something. You would think that would make them look at him. We know that Jason Mao was central to some of these people meeting. So why would they have not questioned him? I don't know. Maybe they have. And they just haven't talked about it. We have to remember the information that we know is probably 0.1% of all the information that Rob Wood knows. And he's not telling us anything. And that's good because that will protect the integrity of the case going forward. Let's see. Lisa Hogan asks if Garrett spoke to the defending attorneys before he taped the conversation and it was a setup. We don't know that. And that's something that I'm surprised Evans didn't ask. Wouldn't you have wanted him to ask that? You know, Garrett Smith, what was your relationship with John Pryor or Mark Means prior to the events of blah, blah, blah? You know, lay that groundwork. Get that foundation that Pryor's always screaming about. This is important. And so I'm a little nervous about this. I don't think Evans took this seriously. Maybe he thought it was a slam dunk and he didn't have to do too much. But there could have been a lot of information that you got out of Garrett Smith. So, a reporter interviewed the daughter's neighbor about the pool. Oh, yeah, see, I don't know how to say this. I like to deal with information that has been officially entered into the record, right? This is one reason that, even though I was talking about it earlier because I was just all angry and crazy, I will not ever interview a family member or friend or anyone involved in an ongoing case, because that can really screw up the case. I could unwittingly ask Summer something very bad that could throw off the whole thing. You know, I won't do that. I don't think any YouTuber should be doing that. I really don't. There's too much at stake. You know, I think the justice for JJ and Tylee is at stake here. I don't want to have a part in screwing that up. I don't. So when it comes to the pool party thing, unless we hear testimony, sworn testimony from someone on the stand or in an affidavit or probable cause form, anything like that, it's just rumor. It's just rumor. So that's all I got to say about that. Nate Eaton could interview Summer. Sure, he could. But at this point, I think that'd still be a dangerous thing. Even though he's an actual reporter and a very good journalist, I think interviewing anyone who's a potential witness in this case is a bad idea. Bad idea. You know, believe me, I would love to sit down with some of these people and be like, all right, tell me what you got, you know. But it could just mess everything up. Pandora's Karma says, isn't it witness tampering and witness intimidation when Pryor said he'd put all the you know, yeah, Pandora's Karma, that's a good point. When Pryor's up there saying, I'm going to bring all the witnesses in for a pretrial taint hearing and da-da-da-da-da-da-da. What if they're watching this hearing? That could make them feel a little intimidated, would it not? You know? So, yeah. I agree, Pandora's Karma. That's, you know, it's a thing. The stuff happens all over the place. As told by who wants to be hauled into this shark show? Not me. Oh. Justin Love confirmed Mindy Gee is a support staff member in Rob Wood's office. Excellent. Thank you. Now, it seems that she is highly qualified. Lots of accolades after her name. Oh, Lori Hellis. All right. If you look in Discord, Lori, I gave you, there's a link there in our private messages to StreamYard. If you click on that, it would bring you right into the broadcast and I can add you to it. You don't have to be on camera. You can just use a picture if you want, or you can be on camera and we'll test your mic. And then I just want you to answer my questions because I'm really stressed. I am stressed about this. I tell you what. Oh, man. Let's see if we can get this going. That would be wonderful. We still have about half an hour to talk before the hearing comes back. Man. Let's see. Just checking on chat. Trying to follow the chat. Eyes are so bad. Yeah. The chat gets scrolling pretty quick sometimes. Sometimes it does. Now, we should be back in about half an hour with the court. Might want to have some antacids ready or something just in case. I'm just checking Discord to see if Lori got my message. Oh. Lori Hellis is in the house. Ask her all what went out. Yep, that's my plan. Yep. I want to hear. One of the first things she said was that she understood why the judge did not allow Summer's testimony. And I was so angry about that. I was like, well, how could he not do that? But there's apparently a very good legal reason for that. So that's what I want to hear. We will find out. They said back at 4:30. Isn't that? Oh, that's just a few minutes then. I'm not sure exactly. I thought they said an hour, Sarah. I'm not entirely sure what they said. Anyway, I'm watching StreamYard, waiting for Lori, see if she can get in. And the court is still on break. I do have it live. The image that you're seeing on the screen, that is live from the court site. So we are just waiting. Parmdari needs some tequila. I am right with you. I'm with you. I'm not sure what they mean by sandbagging. Thielen, I'm not sure what that means. She thinks she's too pretty for prison. Well, she has nothing coming. She's been there for a while now, you know? No great sign of getting off. Or getting out, anyway. Oh, man. Lori, I'm not sure if you can still hear me. If you can, if you look at our private message in Discord, there's a link for StreamYard. It's a website, so you shouldn't have to download anything. Just be able to click it, and you should pop right up, and I'll see you. We'll do a quick mic check and make sure it works. Let me get you a working Discord link for Lorianne. Invite people. Copy. Right, here's a link for Discord if anyone who's not in our Discord currently. We do discuss the case around the clock in there. That's where I file all of the documents that we need, and it's absolutely free. So I like Discord a lot. M. Aspen, no, I would not collab with Scott Reich. Not a thing I'm interested in doing. Sandbagging in poker or cards means holding out and not showing up playing cards last minute. Oh, all right. That makes sense. I do think Rob Wood is doing that to a degree. I really do. He could have brought so much more information out in the preliminary hearing, but he didn't because he didn't need to. I think he brought out just enough information to get that done and not a drop more. So I think he's playing everything very close to the vest. Remember that Rob Wood knows the results of Tammy's autopsy. You know, we haven't heard anything about it. He's not going any further than he has to. Take a moment and thank everyone who supports the channel. We all benefit greatly from your generosity. Knowledge. Oh, well, thank you. I appreciate that a lot. Discovery. And in Discovery, one is not supposed to do this. He has timelines. There's a time limit for when he has to turn everything over to Discovery. But he doesn't have to do that until he has to do that. Does that make sense? He has time. He doesn't have to turn over to Discovery till the judge says, here's the date. All the Discovery must be handed over by this time. And if it's not that time yet, there's no need to turn it over. So I think that's what Rob Wood is doing. And certainly there's going to be some blurry lines in this because there's a lot of information that Rob Wood has that may be coming for murder charges, not necessarily these conspiracy charges. So he has to keep that very clear of what has to be turned over for this case or what can wait until the murder cases. So they can't go back and say, well, you should have given us to that then. You know, so that's going to be tricky. Yeah, I don't care much about Lori's hair either. Truth be told. I assume that Summer contacted him last second before the hearing. Yeah, Thielen, that's what it feels like to me. I mean, we don't know for sure, but it does sound like Summer contacted him yesterday. It was like, I want to see the court. Lee Vogel, you did not miss Gee's testimony. She was not called. The judge had a couple rulings on that. He ruled that Summer Shiflett could not come and testify, and Mindy Gee's statement, her affidavits, would have to be redacted for hearsay. So they did not call her at all. So yeah, we got to hear nothing from that. That's a little sad. I really want to see what they had to say. But oh well, that's for another day. Lori Heller says, I don't think Wood will be disqualified, but I think the defense did some damage to his credibility. Yep. Mm-hmm. And Lori, I was watching Mark Means' rebuttal, and I was starting to feel really like, dang, Mark Means got it together for today. His closing and his rebuttal, I thought, were pretty strong. But here's a question that I have for Lori Hellis. In my mind, the fact that this meeting that Rob Wood had with Summer Shiflett was an informal meet and greet. It was not an interview, deposition, or interrogation. To me, that's a big deal. And that means that some of the things the defense is alleging here don't really apply. Is that true? Or does any interaction the prosecutor might have with a potential witness covered under the same body of professional conduct? That's my question. Lori says, there's so much to unpack here, it's hard to do it on the fly. I don't think Evans did Wood any favors in his presentation. Okay, I agree with that 100%. I thought it was a little bit weak. Marie Smith, I have no idea. I'm sorry. Maybe check on Twitter, some information from that case. Means took his Adderall. Oh, well, I won't say that, but Means seemed very focused. His points were clear, and they were a bit compelling. And I hate that. I really, really do. Oh. Sorry, slurping my soda again. It's a thing I do. It was in a hallway, not even a table. See, that's one thing that I think Evans really missed, is he did not really stress the fact that Garrett Smith told several different stories. That's the problem with any witness. If you get a witness on the stand and they start telling different stories, the attorneys are going to jump all over that like crazy. But even Evans just kind of let that go with Garrett Smith, and I find that strange. Very strange. I heard those bells and thought something came through my front door. Oh, I swear PTSD from this case. And it's Tylee and JJ. You see, Cynthia Berg, I was thinking that too. I'm very surprised that Evans didn't bring up the fact that their first witness could not tell a straight story. To me, that's really problematic. Summers' lawyer never objecting to what Rob said is huge. Yep. To me, that's another big point. Why did Garrett Smith never object to anything that was happening during that conversation while he was standing there recording it? Andrea, welcome to the team. It's great to have another channel member. Thank you for being here. I really appreciate it. All right, Lori Heller says, it doesn't matter how you characterize the contact. The prosecutor has to conduct himself ethically. Okay, so the fact that it wasn't an interrogation or deposition or interview, that doesn't change the fact that Rob Wood has to work within certain confines. All right, that makes sense. Well, I'm hearing a noise. It could be time. We can get back to StreamYard and see. Oh, come on. Somebody said, oh, I think you did the right thing. And then they cut the mic off. What right thing? Tell me. Yeah, Jess, that's a really good point that I'd like to talk about longer. How comfortable the Zoom meetings are as opposed to sitting in an actual courtroom, and how that can change people's perceptions of what's happening. All right, I think they're getting ready to come back. So very soon now, we should hear what's going to happen. Oh, man. Gypsy Soul, I agree with you. Yes, Summers' attorney, Garrett Smith, recorded the meeting. We do not know for sure who knew that he was recording it outside of himself. And he allowed the meeting to go on without objecting or shutting it down at all. Didn't make any statements about, hey, you shouldn't be asking that. Nope, nothing. But then presented the recording to the defense as if this is proof that Rob Wood did all these terrible things. Well, didn't he do a terrible thing by letting it happen and not objecting in the moment? That seems pretty terrible. But what do I know? All these people seem terrible to me. She's going to testify favorably for the prosecution. She does not want charges. They offered Zulema and use immunity. Why would they not offer some of the same? I'm not sure. Maybe Summer doesn't have information that could be incriminating for herself, so she didn't need a deal. Oh, Sam. Well, hi. I don't know your old moniker, but hello. Certainly enjoyed chatting with you the last few days. I just feel John Pryor needs to be reprimanded on his conduct. I do too, Gulf girl. All right, Lori Heller says they didn't offer Summer use immunity because she didn't have any information that would justify it. Okay, that makes total sense. Zulema, on the other hand, must have had something. And I can't wait to find out what that was. Well, we know, seen a 27-year practicing attorney take the oath, and then during the hearing set up on Zoom, walk to his door to see who was knocking. Yeah, we did. And the other guy in front of his green screen, reaching right through it to answer the door because his kid knocked or something. Oh, man. You see, that kind of stuff you don't see happen in a courtroom. Nope. Man, that's, Jess's point was that these Zoom hearings for things like this make it far too comfortable, so people aren't taking it quite as seriously. It doesn't have the mental consequence of walking into a courtroom with the lights and the bailiffs and the judge and the desks and that's a little bit intimidating for a lot of people, but it also impresses upon you the seriousness of what's happening. Sitting at your desk or in your bathroom with a green screen or whatever doesn't make you feel like this is all that serious, And I think that's a problem. That may be something that we're going to see a year or two from now as some of these cases progress, looking back on all the Zoom hearings saying, hey, that caused some problems. That would be interesting. I'd like to see some studies on that. Lori Hella says, for me, the big takeaway is that they got important information from Zulema. Yep. That is a big deal, because what could she know? She could know a lot of things. She could know about the Charles Vallow's death. She could know who shot at Brandon. She could know who shot at Tammy. She could know about Tammy's death. She could know how and why Alex died. She could know about the children. She could know about conversations between Alex and Lori and Chad and all this stuff. She could have a wealth of information for the prosecution. So that could be quite a thing. Sam says, we're old pals and I live in British Columbia, Canada. Oh, well, hi. I like Canada, except Montreal. I'm not going to Montreal. Yuck. Screw that place. Lori Howe says, I agree Zoom hearings are too convenient, but do take away, they're convenient, but they take away from the solemnity of the proceedings. Yeah, that was something that Jess and I had talked about, and Rosie and Feeding It in Discord last night, how that's something that I hadn't even thought of before, but it really does. Like for me, if I had to give testimony right now, suppose, I was called in this case for something, having to get all dressed up and go to court and go through security and look at the bailiffs and look at the people sitting there, and I would be like, okay, this is serious. Eek. And that would impress upon me being like, I have to be very honest and very composed, and oh my goodness. But sitting here at my desk in my bedroom, like, yo, sup, it doesn't feel serious at all. So yeah, that may be something that we need to take into consideration with the proceedings that are going on right now. So we certainly saw some, what I would say, unprofessional testimony from the two expert witnesses that Pryor called. I didn't think that was good. And the pants, Freya. Yeah. Let's hope everyone's actually wearing pants. Oh, goodness. But yeah, Reverend Darlene Lindstrom. My cat jumps up on my desk all the time. Now, granted, I'm not on camera today, but if I am on camera, you do see my cats walking back and forth all the time. Can you imagine? You're here testifying in a case, and Jack jumps up on the camera and puts his butt on screen because that's what he does. You know what I mean? It's like, that's not professional. You don't bring your cat to a courtroom. So yeah. It's a tough situation. But at the same time, I'm very glad that we have the technology like Zoom to keep these cases progressing. Because imagine if we didn't and nothing was happening until the plague was over. We have people sitting in jail for years who can't have their cases heard. We have, guilty people may be out on bond that we can't get them incarcerated because we have to wait for a year till it's safe. So I think the Zoom is the lesser of two evils, but I think maybe if there was a way to look at the psychological impact of it and find a way to deal with that, that would be great. That sounds like a good thesis project for anyone in psychology school, like my daughter. Maybe I'll have her look at that. That would be cool. Something else about the dilemma. Supposedly I've heard from a third party, so I'm not 100% sure. She was known as, M. Aspen. I don't do that here. One thing that you're going to find about this channel is I don't do that stuff. I'm not going to talk about they did satanic rituals and they were witches and da-da-da-da-da. No. Not somewhere you want to go with me. Nope. I make fun of Zulema saying she makes earthquakes happen because that's funny. But that's it. Oh, let's see. Is Wood still in? So far, Leah Free, we are waiting for the judge to come back. They'll be back any minute now. I have heard noises in the courtroom. So they're getting ready to come back. And we will hear the ruling of the judge, I hope. We shall see. That's all speculation. Yep. Lots of speculation. I try to avoid that as much as I can. Because rumors get out of control sometimes and can actually hurt the case. So that's why my coverage is mostly, here's what was filed in court today. Let's read it. Here's the hearing. As opposed to, I heard that Zulema bought a chocolate milkshake when Alex really wanted vanilla. No, I don't do that stuff. So yeah. Let's just deal with court papers. I like court papers. I'm good with that. Oh, all right. I'm checking the court again. They should be here any minute. There are some noises happening. All right, so this is going to be interesting. I'm a little nervous. I'll admit that I am nervous that the judge might side with means and prior, although, like I said before, I think the precedent issue is really going to temper the judge's choice here. Because I think if he sets this precedent, that's going to open the door in the future to just about anybody trying to use this as a way to kick prosecutors or even defense attorneys off the case. So why do you think Alex and Zulema got married? I think it was orders from on high, from from Lori and Chad for business reasons. In other words, the almighty dollar. Zuzu, thank you for the super chat. Zuzu says, thanks. I can't talk anymore. I'm trying. Zuzu says, thanks for hanging in there on this long day. Oh, it still feels shorter than the other day. Thank goodness. But yeah, I'm not leaving till I get resolution on this. I need to know what happens. Hot Scorpio says, yep. Judge Boyce doesn't seem like the type to want to set precedent. Yep. That's going out on a pretty big limb. Can Rob Wood still be part of the trial if removed? Sabrina, I think so. Maybe Lori Hellis could back us up on that. I think he can still take part in the prosecution team, although he won't sit first chair. Although I also believe the defense could ask for him to be completely barred from that. They already tried that once with a motion for a judicial protective order against Rob Wood. So we'll have to see what happens there. What am I slurping? I am slurping some Diet Coke, which reminds me I should have another slurp. Fantastic. Let's see. I just lost my job. Oh, Andrea, don't worry about that. Nobody has to donate here to be welcome. Absolutely not. And I'm very sorry you lost your job. I'm sorry. I hope you find something soon. And Lay D says, thanks, Evan. Thank you for the super chat, Lay. I really appreciate that support. That is wonderful. It makes sitting here a little bit easier. But yeah, I'm really nervous. Okay, Lori Hellis says, I'll be working on a recap for my newsletter this evening. There is so much to unpack. I tried to listen to some of the closing during this break, but I'll need a few minutes to synthesize. All right, excellent. Some of the mods have been dropping links in chat. There's a website called the LoriVallowStory.com. That is where Lori Hellis has a free legal newsletter that you can sign up for. And whenever we have hearings or stuff like this happen in the case, she breaks it down, puts it in a newsletter, and it gets emailed to you free of charge so you can know what's going on. All right, so I definitely recommend that you sign up for that. It is fantastic. She's almost always here in chat too. Whenever doing live hearings, she answers all your questions. So you can show her that support. That would be wonderful. If Wood is removed, he would not be involved in the trial. Okay, interesting. I was hoping he would still be able to be on the team, but yikes. Let's hope that the other prosecutors would be able to pick it up and not drop the ball. Alcoholic beverages if you need it. Yeah. Oh. Yeah, the LoriVallowStory.com. That'll take you right to the website. Just sign up with your email address and it gets sent to you right away. Chelsea Diaz, oh my goodness. Thank you for the super chat. Wow, I think that's the biggest super chat I've ever seen. Oh my God, thank you so much. Chelsea says, for your time today and yesterday, I appreciate you and your input. Oh my goodness, thank you so much. Wow. Oh my God. That's amazing. Thank you so much, Chelsea. I really, really appreciate that. Oh man. Yeah, that's fun. All right, what do we got going on? I'm going to refresh. I know I heard noises in the courtroom a few minutes ago. It's been silent ever since, but I'm actually starting to get a little jittery now because I need this resolution. I really hope the judge comes back and says he's going to deny the motion. Rob Wood will return, but then we know what's going to happen. We heard John Pryor threaten what he's going to do if Rob Wood stays on the case. So we're going to be busy if he does that. We're going to be busy because he's going to bring all kinds of other motions just like this. You know it. I mean, they haven't even mentioned his meeting with Zulema. Are we going to have to go through all of this for Zulema too? And that meeting, he said that he was going to bring pretrial taint hearings for every single witness. Really? This is going to just go on and on like an unending nightmare. Oh, man. At the end of the day, remember they're running out of money. That is true. That's a good point. Oh, I hear noise. I hear shuffling. Someone's got their crayons out. All right, I'm going to go full screen. Mute myself, and here we go, friends. Good luck, Rob Wood. I don't know why you guys can't hear. Hold on. 1 second.
As has been pointed out.
Can you hear it now?
By both the experts and in argument, there really are no Idaho cases directly on point to identify what is the precise standard for this motion to disqualify a
Oh my God, why can't you hear it?
trial. And there's no Idaho.
Yes, you hear it now. Okay.
Court's aware of where this remedy has been ordered by a trial court in a pending case. Neither defendant provided any citation for an appropriate standard of review but made argument in support of their belief of what the standard should be. The state has referred the court to a standard in the Weaver versus Millard case, which was set forth in the state's brief. That case is a civil case, and while it's instructive to the court, I do share a concern that was raised by Mr. Means in his rebuttal argument that the civil standard may not be appropriate for a criminal case, and that would be because of the heightened duties that a prosecutor is charged with and the additional constitutional protections that are afforded to criminal defendants versus a civil standard. And so in the court's opinion that the Weaver versus Millard may not be the correct standard and will not be used for determining these motions at this hearing. There is some Idaho case law out there that for good cause, a trial court can in its discretion appoint a substitute attorney for an indigent defendant, for example, and that would be State versus Lippert, 145 Idaho 586. However, that is for the constitutionally guaranteed right of representation of an indigent defendant and does not necessarily apply to a trial court having the ability to order a substitute attorney to represent the state. In looking at other jurisdictions then, the court has located a precedent out of New York that is persuasive and will be adopted in this case, as I think this is a novel issue in terms of precedent. The case I'm referring to is called State versus Paperno, a 1981 case out of New York, found at 54 New York 2nd 294. And that case deals directly with the issue of a defendant's pretrial motion to disqualify a prosecutor. The standard as stated in that case is as follows. It indicates first, the burden is on, well, let me read that directly from the case. The standard they use is that on a pretrial motion to disqualify the prosecutor, it is incumbent upon the defendant to make an adequate showing that the pretrial activity of the prosecutor will render his participation in the trial unfair. A mere assertion by the defendant that he intends to question some aspect of the prosecutor's conduct is insufficient. Rather, the defendant must demonstrate that there is a significant possibility that the prosecutor's pretrial activity will be a material issue in the case. So according to that, the burden is on the defendants to make an adequate showing that the pretrial activity of the prosecutor will render his participation in the trial unfair. And second, there must be a showing that there's a significant possibility that the prosecutor's pretrial activity will be a material issue in the case. So in reviewing then the motions with that standard, I look at the motions which mirror each other in their allegations. The allegations are, number one, that the prosecutor alleged misconduct violated due process rights of the defendants under the Idaho and U.S. Constitution, right to a fair and impartial trial, that the prosecutor engaged in coercive, unduly influential, and intimidating tactics to manipulate a material witness in this case. The second allegation in the motions is the prosecutor in this case violated the Idaho rules of professional conduct, as well as the ABA rules by his actions. The third allegation is the prosecutor's alleged misconduct could be construed under the witness tampering and witness intimidation statutes as criminal acts. Number four, the allegation that the prosecutor's alleged misconduct has made him a material witness in this criminal case. And number five, the prosecutor's alleged misconduct has caused the potential for future civil litigation directed at Fremont and Madison counties, as well as the prosecutor. And then number six, that the prosecutor's alleged misconduct has included concealing evidence in violation of Brady and Rule 16 of the Idaho Rules of Criminal Procedure. The court would note that in terms of the fourth allegation about the prosecutor being made a material witness in the case, there is some Idaho precedent on authority on when that occurs, and that would be the State versus Aguilar case. And that case is at 135 Idaho 894, and that states that the party seeking such testimony, meaning from a prosecutor, must demonstrate that the evidence is vital to his case and that his inability to present the same or similar facts from another source creates a compelling need for the testimony. Also, that a defendant has an obligation to exhaust other available sources of evidence before a court should sustain efforts to call a participating prosecutor as a witness. And that case states that such motions are generally disfavored. In determining then these allegations in the standard I've announced, then I've considered the evidence submitted, including the submitted pleadings and exhibit and the testimony of the three witnesses, including Garrett Smith, the attorney from Arizona, the expert witness opinions and testimony and reports of Dr. James Davidson and Dr. Samuel Newton. I've also considered, of course, the transcript of the audio recording, as well as listened to the recording of the potential witness in this case and her discussion she had with Mr. Wood, which was submitted in the evidence of this hearing. So getting down to these allegations, counsel's alleged that there may have been or was a violation of Idaho Code 18-2604, which is Idaho's witness tampering criminal statute. Of course, to make a showing or to sustain the burden of violation of that would require the highest burden of proof because it's a criminal statute, so that would have to be shown beyond a reasonable doubt. Regarding the allegations of the Idaho Rules of Professional Conduct, of which there have been many allegations made, including rules 3.3, 3.4, 3.7, 4.2, and 8.4 of the Rules of Professional Conduct, the court considers as a fact finder in this proceeding that the standard of review to determine if there's been any violation of the Idaho Rules of Professional Conduct would be clear and convincing evidence, and that would be found under Warner versus Stewart, 129 Idaho 588, and the matter of Daw, 128 Idaho 80. In regards to those alleged violations of the Rules of Professional Conduct, the Idaho State Bar governs the licensing of attorneys in the state and also enforces the Rules of Professional Conduct. There's an office of Bar Counsel that conducts those hearings, which are administrative hearings. The Bar Counsel has the responsibility of investigating, and I'll quote from a rule, all matters involving possible misconduct called to their attention, and that's Idaho Bar Commission Rule 504B2. The state, in its brief, pardon me, I think I misplaced that, cites to the case of Cosman versus Dinius, which is 165 Idaho 375, which states unequivocally that the district court appropriately recognized that whether to issue sanctions for an ethical violation is a decision for the Idaho State Bar. So in other words, there's a separate governing agency that would make a determination as to whether or not any sanction should be imposed for violation of the Idaho Rules of Professional Conduct. Now, I understand that as the sitting and presiding court in this case, if I were convinced that an acting prosecutor was engaged in conduct that would result in a fair trial, then I would have an inherent ability to grant this motion, even though as I have mentioned, I don't see any prior precedent, or I haven't ever heard of that happening. The Idaho Constitution under Article 5, Section 2 does grant the court with the inherent right to administer justice in a case. But again, the standard I'm looking at for the motion would be the standard out of the State versus Paperno, New York case, which is that the question of one, did the pretrial activity of Mr. Wood in this case render his participation in the trial unfair? And two, was there a significant possibility that this pretrial activity will be a material issue in the case? In this case, then, we're dealing with the comments that were made to a potential material witness who is the sister of the defendant, Lori Vallow. And as Mr. Evans pointed out during cross-examination, this witness may or may not ever be called to testify at a trial. So that's something I have to consider. The prosecutor, based on these allegations, could, of course, choose to recuse himself, but there's been no indication that he is doing that. Mr. Woods could, if the allegations were true, be charged under that statute of Idaho Code 182604. There's no evidence or indication that that has happened. There could be a sanction issued by the Idaho State Bar, and their sanctions may include a private reprimand, a public reprimand, a suspension of license, or disbarment. Those are possibilities out there. There is no evidence before the court that the bar has taken any such action. So without knowing whether or not this potential witness will ever be called to testify at a trial, the court cannot find at this time that the interaction between Mr. Wood and the witness would render Mr. Wood's continued participation in this case unfair, and cannot determine that the prosecutor's pretrial activity will be a material issue in this case. For those reasons, then, the motions to disqualify Mr. Wood are denied. Now, if Ms. Shiflett in the future is called to testify at trial in this case, the court would require a pretrial hearing based on the evidence I heard at this hearing, which has been referred to as a taint hearing. And that was done in the case of State versus Severson, 147 Idaho 694. It's discussed in Head Note 46. So I would require that type of hearing before her testimony based on the evidence been presented by the defendants in this case. The court at this time has no other information of any other such conversations that may have occurred with other potential witnesses. If they did occur, then there may be a possibility of a future request for additional taint hearings for those witnesses as well. But that's not an issue before the court, as the only information submitted was the transcript and recording of the conversation with Ms. Shiflett. So finally, there were some concerning things in the recording in regards to the derogatory comments made by Mr. Wood about Mr. Means. I'm not going to issue an order to apologize or anything to that effect, but it's certainly my practice to always encourage a civility amongst counsel in my cases, and I'll just leave it up to Mr. Wood to determine whether or not he thinks that is an appropriate thing to do in order for continued civility and professionalism going forward in this case. Finally, of course, if the Idaho State Bar were to take any action, this court would be advised of that by the State Bar Association, and this issue may be subject to being reopened for further findings and conclusions if I received any such information. But any decision regarding a sanction for any violation of the ethical rules, if they did occur, is left to the sound determination and discretion of the Idaho State Bar. So that will be the court's ruling on these motions. Mr. Evans, I would ask that you prepare an order indicating that the motions are denied, and also include in the order the indication that the court would require a pretrial hearing to have an in-camera interview of Ms. Shiflett before trial, or, well, don't necessarily say it would be an in-camera interview, just say that a pretrial hearing would be required if she is in fact to testify at trial.
Very good, Your Honor. Thank you.
All right. Mr. Pryor, do you have any questions on the court's ruling?
No, Judge.
Thank you. Mr. Means, any questions on my ruling today?
No, Your Honor. Thank you for your efforts.
Thank you. And Mr. Evans, does the state have any questions on my ruling?
No, Your Honor. Thank you.
All right. Counsel, we do have some other hearings we need to get scheduled, including, I guess, hearing on a motion to compel, change venue, and motions to dismiss. My preference, given the time, and I'd like to just arrange a conference call with counsel to look at calendaring and get these matters set. So I'll be available in the coming week. I'll reach out to counsel and let's look at our calendars and see when we want to get these additional motions scheduled. All right. Anything else we need to bring up on the case this afternoon then?
No, Your Honor. Thank you.
No, Your Honor.
All right. Thanks, everyone. And thank you to the Idaho Supreme Court for their support, as well as Fremont County. We'll be in recess.
Oh, man. Oh, thank God that happened. I am so happy. I'm almost in tears. The stress of this was a bit much. It really was. Why we're so invested in a prosecutor, I don't know. We shouldn't be. We should be investigated or invested in the search for justice. But I think a lot of us feel Rob Wood is the key to getting that justice for JJ and Tylee. And we've got him. We've got him. The first dirty trick of Means and Woods was shot down. Means and Pryor, I'm sorry, was shot down. Rob Wood is staying. He may have to issue an apology, but like someone said in chat, I'm sorry I peed in your cornflakes. Well, let's move on. Yeah, I am so relieved. Definitely going for the champagne tonight. Good news. Good news. Also, I want to take a minute and say hi to Kresha. Kresha is I always say Lay and Carrie. I'm so sorry. Kay and Larry Woodcock's daughter, Kresha. She's here in the chat. She's been hanging out with us for a while. I'm so happy for you. I'm so happy that this happened. I think Rob Wood is genuinely invested in getting justice for the children, not making a name for himself, not being blustery and trying to look all tough. He's here to get justice for these two beautiful children that you see up in the right-hand corner of your screen, JJ and Tylee. That's what this is all about. This entire hearing seemed to take away from that and just give us a pile of garbage to have to deal with. Let's get back now to the focus for justice for JJ and Tylee. I don't think that's going to happen, though. I think John Pryor is going to follow through with his threat with all kinds of crazy filings and hearings, and there's going to be a lot of this nonsense going on. So what I'm going to do going forward, I'm going to spend some more time with Lori Hellis, see if we can get her set up on StreamYard so she can come on and talk to you guys too. We're going to stay on it. I will cover every single hearing that they possibly ever have in this case until we get justice. I don't care if it takes 10 years. I am not leaving until I see justice for those children. So thank you all for being here with me. This has been a very long process. It started 2 days ago. We finally got through it. It was long. It was obnoxious, but we did it. Justice has been served, and Rob Wood will continue. And now we've got all kinds of other stuff happening. They have to reschedule the motion to dismiss, the change of venue, deal with all the other motions that have just been filed, the motion to compel, the motion for discovery. I mean, so there's lots more coming. We're going to stay on it. We're going to cover it minute by minute because everybody here in this chat, the reason that we've sat here on our butts this whole time is because we love Joshua, Jackson, Vallow, and Tylee, Ryan, and we want to see justice for them. That's why we're here. So let's not forget our focus. Man, thank you for spending the day with me. I certainly got a little upset earlier. You know, I'm sorry. I try to stay logical and level-headed, but Pryor and Means made me very angry. They did. So, yep, we all want the same thing. We're all going to get there, and we'll get there together. So you can join us in Discord. We have been popping the link into chat. Links also in the description. You can come and chat with us around the clock. We have voice chat, text chat, all the documents that we get, I put up in there so you can have them for yourself. Kimberly, thank you for the super chat. I really appreciate it, especially after a day like today. It was so great to spend the day with you, and thank you for being here. I appreciate it. All right, I need to go to the bathroom. It's been a few hours. Goodness. And I have to just breathe. Now I'm relaxed. Okay, we got Rob Wood. It's going to be okay. I might also go have a few tweet exchanges with Mr. Skippy Means, just because I have some things I'd like to say to him. Anyway, so if you need me, I'll be around. You can reach me on email. Don't forget to subscribe to Lori Hellis's newsletter, thelorivallowstory.com. Find me in Discord. I have Patreon set up, channel members, all kinds of stuff, so we can interact a lot. There is a video on how to use Discord on my channel. Just look that up if you're having trouble. It'll get you going. All right, so talk to you all very soon. I'll let you know the second we have another hearing to go through and all that great stuff. So thank you for being here. I'll talk to you soon. Stay safe out there, and don't commit crimes because it's not fun. I'll talk to you later. Bye for now.